You've been well taken care of, I like.
All rise, circuit court, on fifth day.
Please bow your head for a moment of silence. Thank you. Have a seat.
Wait, it's supposed to be.
Have you located, let's go off the record for a second. Have you located Mr. Hunley yet?
Yes, he's here
Is he
somewhere.
here?
Let me. Tell later. I go back to.
Commonwealth versus Brett Carver. You got the file, somebody got the file.
Good morning, Your Honor. Jonathan Spalding. I'm standing in for Jonathan Landon here, just trying to get my Zoom situation situated there. That's better. I'm staying with Mr. Carver this morning for arraignment.
This is indictment number 26CR0021, Commonwealth, Kentucky versus Brett Carver. Are you Brett Carver?
Yes, sir.
What are the last four digits of your social security?
5893
What's your year of birth?
76.
Okay. The grand, you have right to remain silent. Your counsel is online here. The grand
Yes,
jury
Your
of
Honor.
Cumberland County has returned an indictment against you, charging you with flagrant non-support. You understand what that charge is? You understand
Yes,
what
sir.
the charge is? Counselor, do you acknowledge the identity of your client received the indictment, waive formal reading and arraignment, enter plea of not guilty?
Yes, sir, I do.
Trial motions.
Yes, sir.
You want me to give the defendant the copy of the indictment?
Yes, sir, please.
Yeah, I'm signing a reciprocal discovery order. What date is the negotiation date in it for next month?
Your Honor, I don't know at this time.
Judge, let me take a look at my calendar real quick on that. I think Jackson and I had already set.
May 28th, so the court is 27th.
Or it might have been that he and I couldn't come up with one, honestly.
27. 27.
27, so I'm just gonna be there.
Okay, your next court appearance is the 27th, and your attorney will be responsible to get a hold of the Commonwealth Attorney's Office to establish a negotiation date between now and then. And
May 27th, Your Honor.
May the 27th, and you can tell counsel that if he wants permission to appear by Zoom, that he doesn't need to wait till the morning of, that sort of thing, because these people have a right to know when he's going to be around here, and I'm not pleased with it, okay?
Well, I don't think he knew he was going to be unavailable, Judge.
Thank you very much. Jerry Compton.
Good morning, Your Honor.
Good morning. This is 26CR006. Are you Jerry Compton?
Yes, sir.
Were you born in 1973?
Yes.
the last four digits, social security number 4287. What does the Commonwealth have to have in this case here?
Your Honor, this needs to be passed. I understand that we're having some difficulty getting body cam from state police.
Okay, we'll pass it to the 28th, and if there's a negotiation day needed between now and then, the Commonwealth will contact Defense Counsel.
Your Honor.
Once that's established, you'll be responsible for attending that on the date, and but the next thing is the 27th. May the 27th. It's not the 28th. It's May the 27th.
And depending on the video, we may have it worked out that day, and we may have motions. And I do have Mr. Bryant on at 10:30. I will appear remotely on it.
That'll be fine.
I'll have it. I'm a big.
Mary Jane Crawford. Commonwealth versus Mary Jane Crawford, 26 CR 0007. Are you Mary Jane Crawford?
Yes,
You born in 1972.
yes,
Last four digits, social security number 7307.
yes.
If you had an opportunity to look at the pre-sentence investigation report done by probation parole.
Already, yeah.
Yeah.
You would look at it, Judge.
Is it substantially correct?
Yes, Judge.
Is there any reason this lady should not be sentenced today?
No, Your Honor.
On plea of guilty possession of controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 3 years probated, 5 years supervised. On plea of guilty to operating motor vehicle under the influence, she should pay a $200 fine and court costs. She should receive, what is the total cost?
$905.
$905. You need some time to pay that?
Yeah, I can pay it monthly.
Well, can you pay $40 a month?
Yes,
Okay, I'll let you pay $40 a month starting 30 days from today. Now, when you entered this plea on both of these, you knew they're enhanceable. Is that correct?
that's correct.
On the DUI, in other words, you get a DUI, it's enhanceable. You understand that?
Yes,
Okay. Meet with the probation and parole officer. The first payment's due 30 days from today.
okay, thank you.
Dustin Dalton. Commonwealth versus Dustin Dalton. 24 CR 0069. Are you Dustin Dalton?
Yes,
Were
sir.
you born in 1990?
Yes, sir.
Last four digits, social security number 8034. Are you have an attorney?
Yes, sir.
Did you go to district court in this case? Direct submit? Yeah, you have an affidavit on him? Okay, what I'm gonna do is go ahead and appoint the Office of Public Advocacy for the purpose of arraignment, and then you'll meet with this gentleman over here from pretrial and do form to see if you're qualified for a public defender, or do you want to hire your own attorney?
I can't afford it.
Okay, well, we'll see whether you can or not, but I'll go ahead and let counsel stand in. The grand jury of Cumberland County has returned an indictment charging you with flagrant non-support. You understand what that charge is?
Not paying child support.
Okay, your next court date will be on May the 27th, and you'll need to keep in contact with your attorney about any negotiation day. I'm signing a reciprocal discovery order that requires the Commonwealth to provide all the information they have to help you prepare for your defense. Your appearance on the 27th is a condition of bond, and appearance on the negotiation day is a condition of bond. Counselor, do you acknowledge the receipt of the indictment, the identity of client, waive formal read and arraignment, enter a not guilty plea, waive formal arraignment, enter not guilty, reserving all pretrial motions? Okay. 27th, you'll step over here, young man, and fill out the affidavit to see if you're eligible for a public defender. This gentleman on the right over there. James Flowers. Commonwealth versus James Flowers, 26 CR 0024. Are you James Flowers?
Yes.
Good morning.
Yes.
Were you born in 1975?
Yes.
Last four digits, social security number 7390. Do you have an attorney?
Yes. Yes.
Who is
I'm
your-
here, Judge. I had surgery. and I
Johnny
couldn't-
Bell.
It's on Zoom, Judge.
Mr. Bell, I understand you had some medical issues that you need to be on Zoom today. Is that correct?
I did, Judge. I had surgery day before
You don't need to
yesterday.
tell us. We don't, I respect your privacy.
I appreciate that.
You have a right to remain silent, Mr. Flowers. The grand jury of Cumberland Circuit Court has charged you with the operating a motor vehicle under the influence, fourth offense, criminal mischief, second degree, driving on suspended operator's license, failure to maintain insurance on a motor vehicle, and no registration plates. Mr. Bell, do you acknowledge the identity of your client? And have you received the indictment yet?
I have not, Judge.
Okay, well, you want us to email it or text it to you? How do you want us to get it?
Whatever's easiest for you, Judge. Email, it's fine.
Okay, well, I'll have the clerk's office email it. You acknowledge that any client, you will receive the indictment. You, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
Okay, we don't have the negotiation date set up.
Your Honor,
I think it's May 22nd, but I'm
we've been informed that negotiation today will be May 22nd,
Oh.
May 15th. It just changed again.
Yeah.
All right,
Which is it?
May 15th.
May 15th. You'll be here at 9 a.m. on May 15th for negotiation day. And the next court appearance in May the 27th. Both of those are conditions of your bond, okay? Thank you very much. Yeah.
Thank you, Judge.
Yeah. Sign a reciprocal, sign a reciprocal discovery order in that case. Commonwealth versus David Freeman. Are you David Freeman? Good morning. This is 26 CR 0015. Were you born in 1980, Mr. Freeman?
Yes, sir.
Last four digits, social security number 3407. We're here for a pretrial conference.
Judge, I got to meet Mr. Freeman, I guess it was last week, and we've got quite a lot of work, complicated case, different types of charges in it. We can have either your May or June date.
May the 27th, negotiation day on May the 15th. Continue on the same bond. Christian Garner. Commonwealth versus Christian Garner, 24 CR 0097. Are you Christian Garner?
Yes, sir.
Born in 2006?
Yes, sir.
Last four digits, social security number 3014.
Yes, sir.
I understand that this is up for review. What does the Commonwealth have to review here?
Your Honor, I've been informed that the review in this is to see if Mr. Garner has obtained gainful employment, and if he has, for him to enlighten the prosecution and the court of what it is and what he's doing.
Counselor?
Judge, Mr. Garner tells me that he's got an orientation to start at McDonald's in Albany on, I guess the orientation is Tuesday, and presumably the job will start on Wednesday of next week.
Is that true?
Yes, sir.
Okay. You need to get to work over there. If you're not gonna work, you can just sit this thing out. You understand? Okay. Good luck. We'll put it on for review next month, May the 27th. He doesn't have to appear if you can show proof to the Commonwealth. Okay. Jason Graham. Commonwealth versus Jason Graham, 26 CR 004. Are you Jason Graham?
Yes, sir.
Good morning. Were you born in 1994?
Yes, sir.
Last four digits, social security number 3322. We're here for a pretrial conference. What do you have?
Judge, this is one that Jesse and I are working on. I met with Mr. Graham over at Spark. Still a little more work to go, but I feel we're going to resolve this. He's doing very well at Spark. He's about 2/3 of the way through that program. At this point, it looks like Mr. Stockton's offer is going to include some jail time, and we very much want him to complete this treatment before he has to do that jail time.
You need a negotiation day on the 15th?
Well, Judge, if you'd be willing, I'd like to set it out a little further because he's not due to complete this treatment until the 1st of July.
What are the charges?
fleeing and evading first is the felony.
We need to come to some resolution on the case before it doesn't bother me if it includes completing a spark or something as a part of some jail time or something like that, but I want to take another look at it on May the 27th.
Okay.
The Commonwealth has been overloaded with this trial that's coming up on Monday, and that should have been over for a while and get y'all a chance to talk about this in more detail before then. Put the negotiation date on the 15th and on the 27th, and we'll just take a look at it then, okay?
Thank you, Judge.
Thank you. Christopher Hill, Commonwealth versus Christopher Hill.
I said he did agree to push on the motion, but we can get it ready.
Are you Christopher Hill?
Yes, sir.
Good morning. This is 25 CR 0071. Mr. Hill, were you born in 1990?
Yes, sir.
Last four digits, social security number 4432.
Yep.
Represented by Mr. Ramsey. This is for a pretrial conference. What do we have here?
Your Honor, we came to an agreement at the last negotiation day. Unfortunately, there were some errors in the offer. I've spoken with Commonwealth Attorney's Office. We're just going to ask to pass this to the next court date so we can get that taken care of, printed, and we'll be entering complete on that next day.
Mr. Hill, if I order a urine test, will you pass it today?
Yeah, I could, yeah.
But you just need to be cautious. You understand what I'm saying?
Yes, sir.
So you want a negotiation day on May the 15th?
I don't think we need the negotiation date, Your Honor.
Here
Just
on
know the
May the
pretrial.
27th. Between now and then, you stay clean. You understand what I'm
Yes, sir.
saying? Okay, thank you very much.
Thank you, Your Honor.
Yeah. Kinsley Maggard. Kinsley Maggard. 25 CR 0083. Y'all have any information on Kinsley Maggard?
The play worked out.
There is, as the plea has been worked out, if we have a defendant, John.
Is,
Virginia, and you told her about something to here. She hear about something. You told her.
yeah, this is our Virginia person, I've been informed, who was told to be here personally today. She appeared by Zoom last month.
Are you talking about Miss Maggard?
Yeah,
Yes, she did appear by Zoom and we have the paperwork ready to execute. In fact, I think she had already, she had executed it, but I guess we saved it for her to come in person and sign and.
yeah, you need to send a text or email to her and tell her that there's a bench warrant out for her, okay?
Can we, well, of course, I think she's in Virginia as far as I know.
Think what?
I think she's in Virginia. That's where she lives.
That's the reason you need to put, we'll let the bench warrant lay for a while before it's put in NCIC. Y'all don't put her in NCIC yet, to see if there's some plausible reason that she needs to come here because we've accommodated her, we'll allow her to go on Zoom. But no good deed goes unpunished. She might have had a car wreck, so I don't want to, whatever, but there's a bench warrant out for her. Thank you. Landon McIntyre.
What do you think?
Yes.
He's here.
So there's a couple of.
We have to play in this, John.
Did you feel like order? Are you Landon McIntyre?
Yes, sir.
Good morning. This is 26 CR 0016. Mr. McIntyre, were you born in 1993?
Yes, sir.
Last four digits, social security number 8436.
Yes, sir.
I've been informed that there's been a plea agreement. Is that correct?
Yes, Your Honor.
Is this going to be a felony plea, Counselor?
Yes, Judge.
Motion been tendered that says you wish to enter a plea today. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 26 CR 0016?
Yes, Your Honor.
Is your judgment impaired in any way today?
No, sir.
Okay, have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
You viewed the evidence the Commonwealth has against you, believe you're fully informed about your case.
Yep.
You understand that you do not have to enter guilty plea. You have certain rights under the Kentucky and United States Constitution. I'm gonna go over those rights at the end. I'm gonna ask you to understand. If you have any questions during that time period, you step away from the podium.
Okay.
You have the right not to testify against yourself. No one can make you say anything. Right to speed trial, but jury right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. By entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept any recommendation. Prior to accepting any recommendation, I will wait to pre-sentence investigation report done by probation and parole. After reviewing that, if I decide to give a harsher penalty to you, in your agreement, you'll have the right to go to trial. You understand that?
Yes, sir.
Mr. Huntley, what is the Commonwealth's recommendation?
Your Honor, upon a plea of guilty of possession of a controlled substance, first degree, second offense, the defendant shall receive a sentence of 3 years, probated for 3 years, with the probation to be supervised. As part of the supervised probation, the defendant agrees to complete long-term rehab at Mark, which is the facility in Bowling Green, which he is currently enrolled in. Is that correct?
Yes, sir.
Defendant shall pay court costs at the discretion of the court and agrees that any evidence gathered in this case be disposed of in accordance with the laws of the Commonwealth.
Is that your understanding of the recommendation?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes,
Doing
sir.
so of your own free will.
Yes, sir.
Knowing your constitutional rights that explained to us, is it still your desire to give up those rights, enter a plea of guilty, and allow the court to fix your punishment?
Yes, sir.
Do you understand that after entering this guilty plea, any future felony convictions could be enhanced as far as the range of penalty? Do you understand that?
Yes, sir.
Is that your signature on there?
It is.
Yeah, I'll accept the agreement. Order a pre-sentence investigation report to be done by probation and parole. What are the fine and court costs?
$160.
What?
$160.
$160, and we can make arrangements when you're sentenced for you to start to make monthly payments on that then. Okay?
All right.
Okay, thank you very much.
Thank you.
April Nethery. Commonwealth versus April Nethery, 25 CR 0072 73 and 26 CR 0011. Are you April Nethery?
Yes, sir.
Good morning.
Good
Were
morning.
you born in 1981?
Yes, sir.
Last four digits, social security number 5139.
Yes, sir.
Okay, who's your attorney?
Miss Greta, she said she was trying to call and couldn't get through on Zoom.
Have there been any is this the attorney that did not show up for negotiation day?
That is correct.
Okay, issue a bench warrant for Miss Atherton for failure to appear at negotiation. She can, once she's taken into custody, she can set $100 bond and have her to be here on May the 27th. You come back on May the 27th. It's
Thank you,
not
sir.
your fault. Okay.
Thank you.
Commonwealth versus William Owsley. Are you William Owsley?
Yes, sir.
Good morning.
Good morning.
This is 26 CR 0025. Mr. Owsley, were you born in 1966?
Yes, sir.
The last four digits, social security 9744.
Yes, sir.
You have an attorney,
Public.
public advocate? Okay, well, I'll continue that representation.
Yes, sir.
You have a right to remain silent. The grand jury, Cumberland County, charged you with burglary in the second degree, theft, unlawful taking, and disposition. Criminal mischief in the second degree. criminal trespass, attempted to commit murder, burglary and second degree, excuse me, theft of lawful taking or disposition, theft of lawful taking or disposition. You understand what those charges are?
Yes, sir.
Counselor, you acknowledge the identity of the client received it out in the way formal reading and arraignment, interpleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order that will require the Commonwealth to give your attorney information to help you prepare for your defense. You'll be here for negotiation day on May 15th at
Yes,
nine
sir.
AM.
Yes,
Your
sir.
next court date's on May the 27th. Both of them are conditions of your bond. Okay?
Sir.
Great, thank you. Barbara Parrish. Commonwealth versus Barbara Parrish, 26 CR 0022. Are you Barbara Parrish?
Yes, sir.
Good morning. You here, you were born in 1989.
Yes, sir.
Last four digits, social security number 0985. Who's your attorney?
I don't have one.
Did you go through district court?
I did, and my co-defendant had one, but I went like 4 times without attorney.
I think we attempting to get her conflict counsel. I don't know what happened.
Will you sit in for arraignment here? Do you have a conflict in this case? Do you know yet?
I think our office is already representing the co-defendant.
Okay, so we can stand in for the purpose of
Yes, sir.
arraignment only and then try to get conflict counsel. You have a right to remain silent. The grand jury of Cumberland County, the circuit court has charged you with possession of controlled substance, first degree methamphetamine, possession of controlled substance in a second degree, Suboxone, I think. Possession of drug paraphernalia, and possession of controlled substance not in the original container. And you know what those charges are, right? Okay. Counselor, you acknowledge the identity of your client and enter a limited appearance for the purpose of arraignment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pre-trial motions. Y'all will need to try to find her conflict counsel, and the conflict counsel and you will need to be here on May the 15th for negotiation, May the 27th. You make sure that you give this gentleman good contact information for you so this new attorney can get in contact with you and work on your case before then, okay? I'm gonna continue the same bond.
If you can write them in, it's the phone.
Candace Samus,
Mr. Garrett, he's running a little bit behind before.
Mr. Garrett is running a little bit behind, so you just have a seat. We'll come back to you.
Judge, my approach,
Yes.
this back, yeah, it's arrived.
Okay,
Absolutely concerned about it.
okay. Okay, I understand that. Miss Maggard is here now? Miss Maggard, are you here?
Well, she was, she must have been back. Yeah, he was just in here. She
Yeah.
just went back.
Miss Maggard's having a rough day. Janisa Smith. Janisa Smith, Commonwealth versus Janisa Smith. Says in rehab. I don't know what that means. What's she charged with? Public advocacy, y'all represent Janisa Smith.
First time alert, decision, ran charge, yeah. First time alert on this. Hi, Mr. Warner, where she's at.
Judge, I talked to her before she had left. She failed to report to me. And I asked her where she was, and she was getting on a bus to go to rehab. She did not have permission to go to rehab. I did confirm that she did receive the letter notifying her that she had to be in court today. She called me from the treatment facility a day or two ago and asked if she had to be here, if she could be here by Zoom. I told her it'd be in her best interest to be here in person.
Where is she?
I think it was an art facility, I believe.
Yeah,
But-
issue a bench warrant and we'll know where she is next month. Thank you. Cody Stinson, Commonwealth versus Cody Stinson. Just in the hospital. Is it the same?
That's the
long-term problem.
email that I got today. I've got my work.
The document that has been presented to the court. It's not on stationery or anything. Identifies Miss Jackie Everett as a social worker, I guess, hospital social worker. Says that Mr. Stinson was admitted to University of Louisville on 3/18/26, where he remains. If you need information, call 502-569-4810. I'm gonna put this off till next month again. Council, you try to obtain information concerning your client between now and then and communicate to the Commonwealth.
Last I heard, he was looking at a bone marrow transplant. That's what they were talking about. According to his mom, but I haven't heard an update since then.
Well, I thought he wasn't like coherent or something for a long time. It was near death. I didn't
They
know.
don't think he can make it without that.
Okay. Put this in the file. We put it on the 27th of May. Savannah Warner. How are you, Savannah Warner?
Yes.
Good morning. You're here on 24 CR 0024. Ms. Warner, were you born in 1997?
Yes, sir.
Last four digits of your social security number 9615. We're here for review. What does the Commonwealth have to say?
Judge, this is here on an other, quote, other hearing. There's no motion to revoke.
She completed her report in Oldham County, and that case got transferred out here. It's exactly what time she put it back on the docket to review her probation, make sure she has the person
Make sure she's what?
being supervised until her probation period's over.
She is, Judge. I've already transferred her supervision to Officer Payne in Clinton County where she resides. She is currently being supervised by probation parole.
You did finish the drug court
Yes,
program
sir.
up there. Okay, well, make sure have you met with Officer Payne yet?
Yeah, I just went on Tuesday. That was the second time I went to see him.
Okay. Well, just comply with his directions and this too shall pass, okay? Thank you very much.
Thank you. I'm all good.
Well, I don't know whether you're good, but you're out of here.
Thank you.
Yeah.
Thank you.
Kinsley Maggard,
Yeah,
go check on Miss Maggard.
she had a long trip in, she might have needed a bathroom break.
Have you had an opportunity to talk to her there?
Not this morning, but we've gone over the paperwork before, she just needed to sign.
Okay.
Withdraw that to bench warrant. Commonwealth versus Kinsley Maggard, 25 CR 0083. Are you Kinsley Maggard?
Yes, sir.
Good morning.
Good morning. I'm so sorry about being
That's
late.
okay. You're here. I'd rather be Kinsley Maggard, late than the late Kinsley Maggard, right?
Right.
Okay. Were you born in 1997?
Yes, sir.
Last four digits, Social Security 1987.
Yes,
I
sir.
understand that you're going to enter a plea today. Is that correct? Is this a diversion or a felony plea?
Diversion.
Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in 25 CR 0083?
Yes.
Is your judgment impaired in any way today?
No.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you, believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea of guilty, I need to know that you fully understand those rights.
I do.
You have the right, well, I'm gonna go over it anyway, and then I'll ask you. It might be one, we might have another right here that you're not used to having in your
Sure.
state. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial, but jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept any recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that? I'm going to ask some qualifying questions to you. Have you previously been diverted in the last 5 years? Have you had any felony convictions in the past 10 years?
No.
Are you currently on probation?
No.
You understand if you complete the program successfully, the charges will be dismissed pre-trial diverted and you can have your record expunged. You know that?
Yes.
And you understand if you do not successfully complete the diversion, be brought back before the court, I will schedule a sentencing hearing. At that time, you'll be a convicted felon. That could be enhanced if you had felony convictions in the future. Mr. Huntley, you can from there, I want you to do it from there if you want to.
All right, I appreciate that, Judge.
Yeah.
Count upon a plea of guilty to possession of a controlled substance, first degree, 2 counts. The defendant should receive a sentence of 3 years on each count to run concurrently for a total of 3 years. The 3 years shall be pretrial diverted for 3 years. The diversion is to be unsupervised if and as long as the defendant resides outside of the Commonwealth of Kentucky. The defendant agrees to forfeit a Walter PDP compact 9mm optic, serial number FDS 4609, to the Cumberland County Sheriff's Department to be disposed of in accordance with the laws of the Commonwealth. The defendant shall pay a fine of $500, and the fine shall be, and cost shall be at the discretion of the court. Defendant agrees to have any and all drug paraphernalia and or contraband disposed of in accordance with the laws of the Commonwealth.
Is that your understanding of the recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You're doing so of your own free will.
Yes, sir.
What are your constitutional rights that explain to us it's still your desire to give up those rights, enter a plea of guilty to the charges, and allow the court to fix your punishment within the range permitted by law?
Yes, sir.
Is that your signature on the document?
Yes, sir.
Well, what, are you gonna need some time to pay the cost? That sort
Yes, if I could.
of- Okay, how much was the total?
$720.
Can you pay it at $100 a month?
Yes, sir.
Okay, the first payment will be due, 1 month from today.
Okay.
Now, you're very fortunate as far as being involved, having some drugs with you. It appeared from our previous talks that the weapon involved was not directly related. Anything, but I will tell you that people make bad decisions when they're around drugs and have weapons.
Yes, sir.
So I hope, you're not to have a weapon around you at all.
I don't like guns.
Okay. Okay.
Yeah.
Okay, and you said that was your signature. I'll accept the agreement, sign the diversion order. You get a copy of it before you leave here, and you need to meet with his probation and parole officer.
Okay.
I'll go ahead and sign it now. I'm sure you're wanting to head back home.
already traveled up here, so. Thank you. Don't have, or wait a second.
Yeah.
Okay.
You want to make her a copy of that, you're gonna need to stamp it in, and you can get a copy of it downstairs in a few minutes before you leave. Probation parole officers right there.
She just wait right here. It's not moving around over there. She just wait, just, yeah.
Just wait here, okay?
Okay.
We get one of the bailiffs, take it down there maybe. One of y'all, but one of the bailiffs come up here just for a second. Okay, we don't have anything until, does that complete this docket? Is there anyone else here on this docket, this morning docket? Your attorney's not here yet, I guess, Miss, is it Simus or Simus? Simus?
Yeah.
Okay, it wasn't either, was it? So, okay, let's go off the record. '25 CR 0076. Commonwealth versus Candace Simmons, were you born in 1985?
Yes, sir.
Last four digits, social security number 7515.
Yes, sir.
Okay. We're here for a pretrial conference. Is there an agreement on this case?
Judge, we had spoken about it this week, and the prosecutor wanted to know if we could have 30 more days to discuss alternatives.
May the 15th for a negotiation date here at 9 a.m. and May the 27th, not the 28th, but the 27th, not the red. We have the 27th. I'll continue on the same bond, okay?
Thank you, Judge.
Thank you, Your Honor.
Yes.
Judge, did you have April Nethery, or I think it's Greta we call her,
Yeah, I issued a bench warrant for Miss Adams.
is she not here?
She wasn't here. She didn't appear for the negotiation date. Miss April Nethery was here.
Oh,
But Miss Atherton was not here today,
Atherton.
and she did not appear at the negotiation date either. So I issued a bench warrant.
because I'm here in her stead, could the court recall the bench warrant?
Well, there wasn't anybody here when I issued the bench warrant. Are you telling me that she contacted you to stand in for her?
This morning, yes, Your Honor.
Okay, we'll issue a summons. I'll recall the bench warrant, issue a summons for Miss Atherton to be here. Is she going to continue to represent April Nethery?
She is, Judge, and I can give the court a report right now.
Okay,
If we can
she should
approach.
be here on May the 15th at 9 a.m. for negotiation and be here on May the 27th for the next court appearance.
Sure, and
And she needs to be in contact with Miss Nethery. And if you tell her, if she's going to take cases down here, that she needs to appear here and she doesn't need to just not show up and not contact her clients or anything, because I'm very sensitive to that, as you know, to protect clients' interests. Okay, thank you very much.
and she also has another case, I think it's William Taylor for sentencing.
Well,
I believe she has two more as well.
Two that she's gonna be appointed on, but I don't think she's gonna take those as a result of today's, what happened today, that she's running late and everything, so,
I don't understand what you mean. Has she gone over the sentencing report? Is she gonna
no,
send it to you?
I'm gonna stand in for the sentencing. If I can get the report, I'll talk to the client and then do the sentencing. There are
He's
two
in
other
jail.
cases.
He's in jail.
Oh, okay. Did he get brought?
He's in the Adair County Jail,
Okay.
Mr. Taylor is.
Mr. Garrett, I left a copy of the PSI for Mr. Taylor at the jail yesterday.
Okay, I guess
So
we
you
can.
might be able to contact him, see if he's gone over it, then you can stand in here when we call him. We'll start that docket at 10:30.
Okay, maybe it might be best just to pass it because I've not seen it to go through it with.
Well, here's the problem that I got with passing. He remains a county prisoner. And it costs Cumberland County hundreds of dollars because she hasn't done her deal. So why don't you contact him and see if he wants to be sentenced today, okay?
I'll do that.
Okay. Now, I guess the other case that she had, what was the other, Megan, what was the other case she had besides
Barbara Parrish and Constance Cherry,
Constance Cherry?
but I think she
That's
may
just
end
a
up.
pretrial conference.
Has she already earned an appearance in those two cases? Or she was gonna.
I don't know.
Accept.
The impression she had not yet. I think she
Okay.
said she had just been assigned those two. So she's the EA conflict.
Yeah, so I would just say that for the time being, she's not entered those yet, Judge. I think she'll have to speak to the DPA director and let them know whether or not she'll be able to accept.
Okay,
those
well,
two.
let's just do the sentencing then. You contact on William Taylor
Yeah,
about the
I'll get hold
sentencing.
of him right now.
Okay, thank you.
So we're calling bench warrant and get you consultants.
Yeah, recall the bench warrant issue a summons for her to be here.
And you know, here I heard all the big things which would say.
I don't know whether she's gonna take these other cases. She doesn't take
It's
these.
just pulled out. April Nethery still in pretrial conference. She's gone.
Okay, we'll put her here on the 15th.
That I had Miss Riddle, it looks like Wilson County's on.
Woodford County on there. Let's go ahead and go back on the record. Commonwealth, Kentucky versus Kathleen Riddle, 22 CR 0014. Are you Kathleen Riddle?
Hey, Riddle.
Yeah. Were you born in 2001?
Yes.
Last 4 digits, social security number 4568.
Yes, Your Honor.
Where you got a pretrial diversion revocation. Motion is a comment. We can proceed on this.
Yes, Your Honor. No, Mr. Gardner as a witness.
Mr. Garner, you come up to the podium there. You raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
State your name and with whom you're employed in what capacity.
It's Officer Jeremy Garner with probation and parole.
Mr. Huntley, you want him just to proceed? You have questions?
Yes, I do.
Okay, proceed.
Mr. Garner, as part of your duties, are you supervising the case of Caitlin Riddle?
I am.
And we're here today on a motion to revoke Ms. Riddle. What is the nature of her sentence? You may give us the beginning date on it.
Possession of controlled substance, first degree, first offense, methamphetamine on indictment number 22 CR 14 for the Cumberland County case.
And does she have any other indictment charges other than that one?
She has the Mercer County case with a 25 CR 44 indictment number for trafficking controlled substance, first degree, methamphetamine greater than 2 grams and drug paraphernalia by possessed.
On the case that you're supervising, or have there been any current violations?
Yes.
Did you go through them and go on court exactly what the violations are?
After the receiving new felony conviction in Mercer County, she was directed to enter Journey Pure. She received a violation for absconding. Probation and parole believes that Ms. Riddle was concealing her whereabouts from probation and parole. She was admitted to Journey to Healing September 11th, 2025. She was terminated from the program due to violations of the program rules and guidelines at the time of discharge. Ms. Riddle had not successfully completed the program requirements. Ms. Riddle has not reached out to probation and parole since leaving the program. A home visit was conducted or could not be completed due to Ms. Riddle's last known address being the treatment center. When she was met at she got picked up on the absconder warrant, she was also drug tested and she was positive for fentanyl and methamphetamine.
Does she have any current charges pending against her anywhere?
She was just sentenced yesterday, revoked on her probation in Mercer County yesterday. So she's a state inmate.
What was the nature of that revocation?
It was for the same violations, but it was on the Mercer County 25 CR 44 case.
Right, in February of this year, does she have charges relating to drugs?
She had the 24F case for traffic controlled substance, first degree, first offense. That was what the felony conviction was that got her on probation there in Mercer County.
What is it? She has had a long series of interactions with your organization, hasn't she?
Yes.
What is your recommendation as to what disposition should be made in this case?
That Miss Riddle's, pretrial diversion is voided.
Now, would you answer Mr. Shepherd, please?
She's been on supervision out of the Cumberland County case since March or the 1st of April, 2022.
March 31st of 22, yes.
There was a felony charge in Mercer County in the intervening period in 2024.
Yes,
He was allowed to go to rehab. I guess both courts kind of agreed on that.
yes.
How long was she at that rehab?
She was admitted September 11th of 25 to Journey Pure. I don't think that, and then she was discharged on. I don't have the exact date. I can't find it.
Would January sound about right to you?
That sounds right.
They're about 4 months.
Discharged 12/30/25. So December 30th.
And she actually went back to that rehab. Is that your understanding?
She did return back to that rehab, before she turned herself in.
And she did turn herself in to the local sheriff's, whatever county that was in. She turned
Woodford
herself in.
County.
No further questions, Judge.
Commonwealth have anything else?
No.
You stipulate to the violation?
Judge, I mean, yes, we don't disagree regarding the violations themselves.
What kind of deal has she got going in Woodford County? Is it Commonwealth? Is that where she's serving now? Is it a Mercer County charge?
Yes, Your Honor. She was revoked yesterday. I was notified 4 p.m. yesterday that she was revoked. So she
Was
is.
it Woodford or Mercer?
Woodford holds Mercer County inmates.
Okay, so it's a Mercer County case.
Yes, Your Honor.
Does Commonwealth have any objection to revoking her, and since she's a state prisoner, not having a pre-sentence investigation report? You just let it run concurrent with what she has in Mercer County?
No, we have no objection.
Okay, young lady, whatever they do to Mercer County, I'm gonna let it take care of your thing here too, okay?
All right, thank you.
Okay, and so
Will
we'll
my
just,
time, the time served that I have on my computer, so I can count, right?
well, we'll just run it concurrent with whatever they do, and they'll count, the Department of Corrections will count the days, okay?
Okay.
Okay, I hope that you see the error of your ways and you get some kind of help with these drugs thing. You know, it's fentanyl and other things like, yeah, you understand that, don't you?
Yeah, when I went back to the rehab, I wanted to turn myself in because, I hit my rock bottom. My grandpa passed away, and I'm not from Suboxone, so it's helped out tremendously, and,
Okay, well, you work on yourself. Thank you for appearing in Woodford County. You are released, excuse Woodford County.
Oh.
Is Kentucky Correctional Institution for Women on there yet? Wayne County, are you on there? Okay, well, let's go off the record until we get, we got both, Adair County starts at 10:30. Could you go off the record, please? Could you check with There you go. Are you Jimmy Clark?
Yes, sir.
You're on 25 CR 00063. Were you born in 1987?
Yes, sir.
That's 4 digits of your social security number 3975.
Yes, sir.
You're here on a probation revocation. What does the Commonwealth have to say?
I call Officer Garmin.
Officer, you raise your right hand. You swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
You may proceed. Mr. Hunley?
Mr. Garner, is Jimmy Clark, one of your clients?
Yes, sir.
Tell the court briefly what his criminal convictions were for and how much time he had.
It is a 2-year sentence. He was indicted on 25 CR 00063 on possession of controlled substance first offense methamphetamine and possession of controlled substance first degree offense opiates.
When did his supervision begin?
November 2025.
Since then, has he made violations of his probation?
He has.
If so, give the court the nature of the violations and the chronological order in which they occurred.
On November 2025, he was granted probation on Cumberland County case 25 CR 63. December 4th of 25, he failed to report and left the area. On December 8th, he failed to report again. And when he did report at some point to that officer, and he was positive drug test for meth, opiates, and THC. On February 5th of 26, he was also positive for THC. February 16th, he received a DUI second in Wayne County on case number 26T00057. On February 16th, he had a firearm charge in Wayne County, 26F00021. February 18th, he failed to attend treatment. February 24, 2026, he absconded supervision. February 26th of 26, he failed to report. On March 6th of 2026, when he was picked up, he was positive for meth and THC.
What is your request after having made a thorough examination of his record and his conduct while on probation?
That he's revoked.
Okay. Now, would you answer Mr. Shepherd, please?
Have you directly been supervising him or someone else?
I supervised him until I transferred his supervision. Don't have the county which I transferred from. Let's see here.
Would he have transferred to Wayne County?
I believe that's right, which is still in the District 3 of my office.
But it would have been somebody out of the Monticello office, not you.
Yes.
When did that happen?
It would have been December.
All right, so when you testified that on December 4th and December 8th that he failed to report, and then that he did report, I took it not too long after that, but was positive, that would have been dealing with you directly.
Let's see. Yes, that he would have reported to me, and then he would have been transferred to the area where he was living.
Okay. Let's see here. You submitted, it looks like to me, you submitted your request for revocation and a bench warrant on March 6th. Is that right?
Yes.
And that's the day that he was arrested on the Wayne County charges.
He was February 16th was a DUI second for Wayne County, and the firearm charge on the 16th.
but he was not, I don't believe, he was not arrested at that time. Was that a complaint that was filed with the county attorney's office and then he was later arrested on March 6th?
Yeah, it was a complaint warrant that was issued after the initial arrest, by that department.
And then, so you haven't been dealing with him over the last, say, since February?
Now, that had been Officer Morrow and then, Officer Morrow.
No further questions.
Do you have any redirect?
No redirect,
Okay.
Judge, I don't think they presented enough, without presenting the case against him in those criminal cases in Wayne County, which we know he's been charged, but we didn't hear any evidence, about it. So the court can't make a finding as to the value
If
of
you're not
those
willing to
charges.
stipulate, we'll have to have additional testimony.
Well, there could,
Let's schedule it for schedule them again for May 27th and subpoena those officers over here paid if we find any.
and Judge, and for the Commonwealth, I would let you know that, Wayne County is, I believe, willing to keep those charges in district court. They're rather weak and they're willing
I
for
don't
him
know
to
about
go.
those.
Right.
I don't know about those when we
That's
get the
my point.
officers over here.
But,
But when I hear drugs and firearms on someone that's out under supervision of this court, I get a little anxious.
Understand.
So we'll see them on the 27th, hold until then. Okay? Thank you. Is Kentucky Correctional Institution for Women on? Did you?
Email the lady that's not being distracted.
Okay. Okay, well, let's go off the record then until we get in contact with them. And we'll be back on the record at 10:30. It's Commonwealth Kentucky versus Beth Garmin, 25 CR 0064. Are you Beth Garmin?
Yes,
Born in 1973.
yes.
Last four digits, social security number 3470. Okay. Mr. Huntley, you want to proceed?
Yes, Your Honor, call Officer Garner.
Officer Garner, you raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
I do, Your Honor.
Mr. Huntley, you may proceed.
Officer Garner, are you probation officer on the case of Beth A. Garmin?
I am.
How long, tell the court when her probation began and what sentence she received?
On March 24, 26, on case number 2564 for operating motor vehicle under the influence of alcohol and drugs.
What sentence did she receive?
She was sentenced to 5 years, probated for 5 years, served 120 days alternative sentence, credit for time served.
And she commenced supervision on what day?
On March 24th, 26.
What has happened to her is in her probationary period?
On March 24, 26, Ms. Garmin was sentenced to 5 years, probated for 5 years, served 120 days, alternative sentence, credit for time served. On March 24, 26, the Adair County Regional Jail refused Ms. Garmin due to the inability to accommodate her medical requirements. Ms. Garmin was inadvertently placed on home incarceration to accommodate her medical needs. On April 2nd, 26, Ms. Garmin violated the conditions of her home incarceration. A probation violation warrant was issued, returning her to the Adair County Jail, where she was then accepted. Upon entry, Ms. Garmin was given a urinalysis by the jail nurse and was on-site positive for methamphetamine. On 4/6/26, this officer was notified of the positive screen and met Ms. Garmin at the Adair County Regional Jail, where Ms. Garmin admitted to sign an admission of guilt form to the use of methamphetamine occurring on or about 4/2/26. The method of consumption was snore or inhalation. Use of Suboxone, Ms. Garmin also tested positive for Suboxone. Ms. Garmin claims to have had a valid prescription, but has failed to provide proof. The use of benzodiazepines, Ms. Garmin also tested positive for benzodiazepines. Ms. Garmin claims to have a valid prescription, but has failed to provide proof.
Do you have any other violations on this?
That's all I have for Ms. Garmin.
And what is your recommendation?
That her supervision is revoked.
Now, would you answer?
Mr. Poindexter, you may proceed.
Officer Garmin, has she been assessed by a social services clinician?
Where she was serving her initial 120 days, she has not had the opportunity to report to the SSC for that part of her supervision yet.
Okay. So we don't know if there's a lesser, a less severe penalty than revocation right now, do we?
No.
Okay, that's all the questions I have.
You have any follow-up?
No, nothing further.
You want to make an argument?
Your Honor, I would simply ask that she be allowed to complete the 120 days that the court has previously ordered and sentenced her to, and then let her be assessed by the social services clinician.
What does the Commonwealth have to say?
Your Honor, I firmly believe that when somebody is convicted on heavy drug charges, gets and placed on probation, give them the break of their life. And then it's obvious from her early efforts that she has no intention of being off drugs, doesn't want to be off drugs. And we just moved that she be revoked.
I think I know too much about this case to decide this myself. Cause I witnessed her outside the courtroom, outside the courthouse that day. I kind of, you know, I think another judge needs to take a look at this because the problems we had with the ambulance coming here and picking her up and her going up the hospital and causing the racket she caused up there and then that sort of thing. I think I'm prejudiced on this thing. I think there's enough here to do what the Commonwealth wants. I have no doubt about that, but I just don't think I ought to make the decision because of what I personally saw. So I'm going to recuse myself from this case and let another judge take a look at this with a fresh set of eyes on it.
I understand.
And I'll sign that today and get somebody else to take a look at it. Okay?
Yes, sir.
Thank you very much. And the new judge can consider the testimony today or require a new hearing, whichever they want to.
Yes, sir.
Thank you very much. And thank you, Kentucky Correctional Institute for Women for participating in this. You are excused.
Thank you.
Okay, it's time to go to the, in 7 minutes, we'll be going to the Adair County Jail, so we'll go off the record until then. Okay, we have somebody that's come in that was not previously here before. We have somebody show up. Okay, let's go back up to that docket. Commonwealth versus Janessa Smith, 23 CR 00109, withdraw the bench warrant. Are you Janessa Smith?
Yes, sir.
You born in 1989?
Yes, sir.
Last four digits, social security number 1768.
Yes, sir.
Okay. What does the Commonwealth have to say?
Your Honor, this is the Commonwealth's third motion to revoke and impose sentence on Ms. Smith. I'd like to talk about Mr. Gardner, please.
You raise your right hand, please. You swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
I do, Your Honor.
Officer Gardner, is Ms. Smith one of your clientele?
She is.
Did this begin with her in 2023 with the conviction for possession of methamphetamine?
Yes.
And her supervision began February of 2024.
Yes, sir.
And she received a sentence of 3 years, is that correct?
That's right.
When did you personally begin to supervise this individual?
March 4th of 24 was her intake at the Columbia Office of Probation and Parole.
how many violations, small and large together, has this young lady made of her attempt to be on probation?
One, two. I'm showing 7 violations.
And what are the nature of?
On March 4th, 24,
Objection, Your Honor. The bulk of these 7 violations have been dealt with, which resulted in Ms. Smith being admitted to drug court and being in there for almost 3 years. I think what's before the court today is what has happened since she was administratively discharged from drug court and went back on probation.
I don't agree with that all over it. I think I entitles like a totality of the situation experience to get a kind of context. You may proceed.
on March 4th of 24, during her intake, Columbia Office of Probation Parole, Ms. Smith was given your analysis, and Ms. Smith was tested positive, admitted to and signed admission of guilt form to the use of methamphetamine occurring on or about 2/28/24, allegedly while incarcerated in Dare County Regional Jail. Ms. Smith was directed to enter and complete inpatient treatment with Protea and was given an entry date of 3/7/24. On 3/7/24, the officer contacted Protea to inquire if she had arrived. Ms. Smith did not. It was reported on 3/11/24 that a conversation Protea had, Ms. Smith was trying to get her admitted, that she had admitted to continued use. This officer was notified and a request was made to get Ms. Smith's transportation to treatment. On 3/12, Ms. Smith requested transportation for the same day and was directed to call back within the hour. There was some confusion there with getting her transported. On 3/13, Ms. Smith failed to report to treatment as directed. After several attempts to get Ms. Smith into treatment, the referral was closed by the SSC. On 3/14, SSC reviewed email from Protea stating that Ms. Smith was already ready to go and said that she could schedule Ms. Smith on Monday to go to treatment. SSC stated that it was fine, but informed her that, and this officer upon arrival, client did not enroll as directed. On 3/19, Ms. Smith has not reported to Protea and failed to report to treatment. In lieu of, she failed to cooperate with probation officer. This officer recommends that Ms. Smith be lodged, and her diversion was voided. On 4/8/24. Probation violation warrant was issued. While at the Dare County Regional Jail, Ms. Smith was requested to provide a urine sample for testing with the assistance of the jail nurse, who was a female observer. Ms. Smith refused to provide that sample. Officer returned at 4:10 and inquired with the jail nurse if she was ever able to obtain a urine sample from Ms. Smith. And the jail nurse stated that she had multiple attempts to raise her from her cell and provide a sample, and she declined. She's had a positive for meth, Suboxone, benzo, fentanyl. We requested revocation, and she was sent to drug court in lieu of revocation. And then she got on Suboxone or Sublocade, and in lieu of revocation, again, she was returned to probation. On 3/24/26, Ms. Smith appeared before the Honorable Court after failing to complete her Cumberland County Special Drug Court program. Ms. Smith denied use of, I'm sorry, back this up a second. Ms. Smith reported to the Columbia Office of Probation and Parole for intake after being returned to active supervision, whereas she was given a intake urinalysis and was on-site positive for methamphetamine. Ms. Smith denied use, claimed it was due to prescription of Adipex. Ms. Smith provided proof of the Adipex prescription. Sample was collected and sent to the lab for confirmation. On 4/6/26, lab reported back that Ms. Smith was in fact positive for methamphetamine. In addition to this officer's experience and training, this officer confirmed with the SSC Greenwell that the prescription for Adipex would show a false positive for meth, but however, a more detailed review by a lab would confirm the difference between amphetamine and methamphetamine. Based on the lab results, Ms. Smith provided false statements and was in fact positive for illegal and illicit substance methamphetamine. Based on the lab results, it has been proven that Ms. Smith has provided false statements and was on-site positive for methamphetamine and attempted to hide behind her prescription of an alternative substance. On 3/26/26, Ms. Janessa Smith was directed to report to probation and parole officer on 4/16/26 at 10:45. Ms. Smith signed a reporting instructions and a releasee report where in her own handwriting wrote her next report day acknowledging that Ms. Smith knew she was to report to this officer on 4/16/26 at the Cumberland County Judicial Center. On 4/16/26, Ms. Janessa Smith did not report to this officer, had called all phone numbers provided. Ms. Smith had no contact could be made with her. Then there was an update. Later that evening, after I wrote this report, at 2:49 p.m., Ms. Smith called this officer and reported that she self-enrolled into ARC. Officer believes that Ms. Smith, knowing she has a revocation hearing, deliberately self-enrolled to avoid.
Objection is speculation.
Proceed.
Self-enrolled to avoid revocation. Ms. Smith was not sent by probation and parole, but obtained several treatment providers' contact information from the SSC. At no time did probation and parole officers authorize, coordinate, or approve misplacement into ARC.
You have anything else, Mr.
No.
Hunter? Mr. Hundley, do you have anything else?
I do not.
You may proceed.
So she came back under your supervision, if not yours directly, probation and parole, March 26th of this year.
March 26th, yes.
And there was a drug screen that ended up being positive for meth.
Yes.
Based on that, you had her see Mr. Greenwell, the SSC.
She was court ordered to have an assessment as well.
Okay. And did that happen?
Yes.
And what was the result of the SSC assessment?
She was directed to do outpatient, I believe, at the time.
IOP?
I believe so, that's right.
Okay. But on her own, she enrolled herself into an inpatient placement
She did.
without your all's knowledge.
That's right.
They're not.
Okay. Nobody, I mean, when did you become aware that she had enrolled herself?
After she made contact with me after she failed to report to me later that evening, she was scheduled to meet with me at 10:46 on that day. She called me at almost 10:50 that evening and reported that she had self-enrolled. And I confirmed with SSC that we did not place her, that she only obtained several placement options, phone numbers, and et cetera of people.
So, in your report, it says the update says 2:49 PM is when she called.
Yes,
No, it wasn't 10 PM, it's 2:49 PM.
10:49.
Okay. No further questions.
You have anything else?
Nothing further,
What's the Commonwealth's position?
that it's Commonwealth seeks a revocation in this. It's obvious to me that she has made no effort whatsoever to comply with the rules of her probation. She's just determined to do what she wants to do. And she has not complied with anything. And I heard, I don't hear well anymore, but I heard you reference the word totality that in a few moments ago. Considering the totality of the evidence here, there's no question that she's not going to comply with probation and parole. She's not going to get any kind of assistance except through fine situation.
Second, just a second.
You know, response to that.
Judge, I think that Ms. Smith would like to testify.
Okay, let's go off the record just a second. I've got a probation parole officer. Hello? Bitch.
Sir,
Okay, what was the instruction? What was the instruction for you from the court and from the legal system after you were administratively discharged from drug court?
to be probated back.
Do you have a record on that, or, I mean, it's got pretty rank hearsay, isn't it?
The court's recommendation?
I didn't do it.
Well, somebody
The
instructed. me.
drug court, do you have a written document that else to the drug court?
No,
I know, the only
I
paper
would-
that was sent to me was I get back on regular probation, probated back out on regular probations with the paper I got in the mail.
What? Okay, let me look at the discharge paper. Would you like it, if you got this?
Just what's the date of the discharge?
March 24th, 2026. You have that?
That's, yeah.
Says wants to take Suboxone shot to help her quit. Excuse me, help her quit Suboxone. She self-medicated on Suboxone after having twins and developed addiction and taking the shot without permission from the drug court. That's what it says. Go ahead.
So
That's all she was saying anyway.
So you reported to probation and parole at the end of March.
Yes,
Okay, did you take a drug test for them?
yes, sir.
What was the result of that test?
Buprenorphine, and methamphetamines, I guess. I thought it was amphetamines, is what they told me, and that's what I signed off on, but I guess it's methamphetamines, which
Okay. And because of that positive test, what steps did probation and parole send you through?
they didn't, the court had ordered me to go see Miss Greenwell, because, still going through postpartum, and my dad just passed away last month. So the court ordered me to go see Miss Greenwell and, see what her recommendations
Who
was,
is Miss Greenwell
the, clinician.
for probation and
Yeah.
parole?
And I went and seen her,
What did she recommend after her assessment with you?
IOP with Odonto, which I was done doing and still was doing up until I went to rehab because I felt like I needed.
Why is it that you decided to go to rehab?
Because I didn't want to relapse again. I was clean for 2.5 years and I was going through postpartum with my twins real bad and I felt like I was gonna relapse again. I just didn't want to go back down that road. Like I found God, I've got my kids back in my life. I had a job, I have a home. I worked really hard for 2.5 years until all this happened.
And when did you, I guess, what rehab are you at?
I'm at White Oak at ARC in Inez,
Okay, Inez, how far away is that?
4 hours.
I know where it is.
Well, Judge, I don't, but, I mean, I know it's far away.
And it's getting me the mental health therapy that I need, that I've needed. I mean, I don't know if y'all ever seen somebody go through postpartum, especially with twins, but it's pretty rough. And then losing your dad after that, like, it got to me and I relapsed one time. I promise you, I did not continue to use. I was in a state of mind in my house and I relapsed and I admit that.
When did you arrive at the program?
Last Thursday.
Which would have been the 16th.
Yeah.
Okay, and you got notice of today's date?
Yes.
And that was,
When did you get notice of today's date?
how did you know about today's date?
Well, I got, the paper from the DA like 3 weeks ago.
The motion?
But I told them, I was like, I have to be at court at 9 o'clock, and they kept on telling me 10, that we can get you there at 10 for the revocation, and I was like, no, I got to be there at 9, so, I mean, I had to leave when they left this morning, is why I was late, so I'm sorry about that, like I told them. And that's why I was late, so.
No further questions, answer anything, call with me for you.
Ms. Smith, do you believe that your use of drugs over the last 2 or 3 years has put your life at risk?
Not the last 2 years, sir, I've been late for the last 2 years. I relapsed one time, and that was last month, last 2 years. I started playing for over 2.5 years.
Yes. When you first arrived at the Adair County Jail, did you have to receive treatment for drug overdoses while you were there?
In 24, yes, I was in a bad state of mind then. I was in a bad addiction then.
And the truth is that they had to give you Narcan to save your life.
2024, yeah, I believe it.
And they had to do that 3 times.
In 2024, yes, sir, I believe it. So not today. I've worked hard these past 2 years to get where I'm at, and like I said, I had
You
twin
can turn
babies.
around, address me, but go ahead.
I mean, I just had twin babies, and when I went through that postpartum, I didn't know what it was or what I was feeling. I had 2 psychotic breakdowns, which I went to the crisis center over.
Who has the children now?
Their
You're in
dad,
the rehab, you're in Inez, you don't have
Yeah.
the children now.
their dad, but they said if
Where does
I,
their dad live?
on 115 Dillon Lane,
What city?
Burksville.
Burksville.
But
So
they're,
wait now,
okay, sorry,
so you went and turned yourself into ARC and they took you to Inez.
yeah.
Where did you turn yourself into ARC at?
They picked me up here at the courthouse.
So you call them
Yeah, I called them,
and they transport you to Inez.
yeah. And they're supposed to send me
And
with
where
my
are you
babies.
working at?
I was working at Tyson's in Albany. And they're supposed to be sending me a place in a week where I could take my kids. I just had to go to this place for 2 weeks because it's a 3.1. And then I'm doing really good right now. And so within a week, I get to go somewhere where I can take my babies and finish the 6-month program, which is what I really want to do. I'm not a bad person. I'm not a bad mother.
Charlie, you have any other
That's,
questions?
On March 26th of this year, less than a month ago, when you reported probation and parole, you tested positive for methamphetamine then, didn't you?
Yes.
Less than a month ago.
Yes, sir. That's when I relapsed. And I was ashamed. I was so ashamed, and guilty is the reason, like, I lied about, like, cause you gotta think 2.5 years clean, and then you mess up, you just, instead of asking for help or reaching out, I just felt ashamed.
But you, at that time, you denied taking methamphetamine. You told them it was amphetamine.
Yes, sir, I did. I lied about it.
So you lied about that less than a month ago.
Yes, I did.
I have nothing further, Your Honor.
Would you like to make an argument?
Judge, I would, as the court is well aware, the road from addiction to sobriety is for most people not a straight line. It's up and down until that point where your stomach's full and from then on, it is a straight line. And I think Ms. Smith hopefully has hit that point. She's shown promise at times, over the course of this supervision.
What I'm gonna do is I'm gonna take the pretrial diversion revocation under advisement on a condition that she go to a residential 6-month treatment. If she leaves that 6-month treatment, residential 6-month treatment, she shall immediately report to the probation and parole office in Columbia. And we'll have an incarceration order, wait for it, and I will consider the evidence that I heard here today. And if she leaves there, she shall be charged with absconding.
Judge, just to be clear, she can stay in the program she's at. That is a 6-month
I'm
program.
gonna send her back. You get to leave here today. But I don't want any more lame excuses. Nobody wants to be an addict. I've never found anybody that want to be an addict. I've found people want to take drugs, but then when they get addicted, they don't want to be an addict. Hopefully, you can come back. Maybe they'll get you a job at some juncture up there. I don't know whether your job will be here. Being a convicted felon won't help you get employed when you get out. I don't want you to be a convicted felon and living and raising these children. Right now, these children won't be able to remember when you weren't there for them. You understand that? But that time will go like this, and you're gonna have to decide whether that needle or that snort is more important to you than being involved in your children's life. That's it's not in the prosecutor's hands, it's not in my hands or probation parole. You're gonna have to decide that.
Yes.
If you come back again as a drug addict and using, I'm gonna have to make a decision that that's more important to you than your children, and then social services and other people have to get involved to see who's gonna raise those children. You understand what I'm saying? Okay.
Thank you.
Yeah. We'll get a copy of that order. Can you draft an order reflecting what the court did today?
Yes, Judge.
Okay. Go back to Inez. It's a long drive between here. Yeah.
We gotta wait for some, for her to think back.
Probably not today. They'll be sent to you.
But I'll get sent to that program.
Okay. Okay, Commonwealth versus Joseph Chad Bryant.
Chad. He's on his way up, Judge.
Mr. Bryant, Your Honor.
This is 26 CR 0026. Are you Joseph Chad Bryant?
Yes, sir.
Were you born in 1974?
Yes, sir.
The last 4 digits of your social security number, 2971. You're
Yes.
here for the purpose of arraignment. Are you represented by an attorney?
Yes, sir.
Your Honor, I'm here for Mr. Bryant.
Okay, you had a separate engagement, got permission to do it by Zoom or whatever. You don't have any objection in representing you by Zoom, do you?
Yes.
So the grand jury of, you have the right to remain silent. The grand jury of Cumberland County has returned indictment against you, charging you with rape, 2 counts, sodomy, 3 counts, unlawful transaction with a minor, 2 counts, possession of a handgun by a convicted felon, rape in the 3rd degree, possession of controlled substance in the 1st degree, receiving stolen property, possession of firearms by a convicted felon, tampering with physical evidence, possession of drug paraphernalia, persistent felony offender 2nd degree, another count of persistent felony offender 2nd degree, another count of persistent felony offender 2nd degree, another count of persistent felony against offender 2nd degree, another count of persistent felony 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 offender 2nd degree, and lastly, another count persistent felony offender 2nd degree. You understand the nature of those charges, Mr. Bryant?
Yes.
Okay. Mr. Cross, do you have a copy of the indictment?
I do, Your Honor, and I would
Acknowledge,
acknowledge this.
you acknowledge the identity of client received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We will schedule a negotiation day on May the 15th. And the next court date are May the 27th. And Mr. Cross, if you want him, you'll need to do transportation orders.
I understand, Your Honor. Thank you.
Thank you very much. Okay, your attorney will be up to see you, Mr. Bryant.
I'll be up there.
Okay.
Denzel Burke.
Switch it up, yeah.
Mr. Bryant's case, I'm signing a reciprocal discovery order to provide discovery to Mr. Cross.
Parker, I'm ready.
Denzel Burke, Commonwealth versus Denzel Burke. 22 CR 0058. Are you Denzel Burton?
Yes, sir.
Born in 1971.
Yes,
Last 4 digits of social security number 1609.
yes, sir.
Okay.
Judge, this is the first of 2 or 3 cases that I think motions have been filed back several months and maybe these folks have been picked up and placed on
Speak
today's
up just a
docket.
little bit.
This is the first of 2 or 3 cases that I think motions have been filed in the past. So I haven't seen the motion. I didn't know anything about Mr. Burton. So I'm gonna need to get a motion from the Commonwealth and maybe put it off to the next motion day.
Is it okay with the Commonwealth?
So the threshold of 6 months in contempt.
This is one.
So this is supposed to be off the file since, correct? Yeah.
I thought about revocation. I apologize.
The revocation is what.
Somebody want to let me in on the deal here?
He's been in.
I was just bringing me up.
Okay, okay. All right, go ahead. Go ahead. Go ahead. Y'all can have some time. Go ahead.
Just we had a hearing on this like 6 months ago. And that's not going on. Held him in contempt.
Do what?
You held him in contempt for 6 months. And so we would just pass this till 6 months down. the road.
Yeah, okay.
Yes.
So this is a case where he was held in contempt for giving
Had a
sick.
hearing, you revoked him.
I revoked him, so
There's never an order done.
just the order of revocation needs to be entered now. And I'm going to go ahead and give him, seems to be conducting himself all right today. I'll let you use this contempt time. It's good time rather than just using this contempt time. That's giving you a break, Mr. Burke.
Yes, sir. Your Honor, did you say I was revoked?
Yes, you were revoked.
I never even got to have the hearing on it, revocation.
Yeah, there was a hearing. You need to talk to your attorney if you want to challenge that.
Judge, I'll have to look at the court file on the
Okay,
record.
that'll be
I
that.
mean, obviously, I
Okay,
wasn't-
thank you very much. Constance Cherry. Constance Cherry. Wait. Let's go back a little bit. Who turned that microphone off?
I bumped it, Judge. My apologies.
Or did Mr. Cherry have anything else he wanted to say?
I don't believe so, sir.
Okay, thank you.
You're welcome.
Mr. Burton.
Got another one that's ready to go.
Constance Cherry. Are you Constance Cherry? This is
Yes.
26 CR 0014. Were you born in 1995?
Yes,
What are the last four digits of your social security number?
3111.
You're here on a pretrial conference. What's the comment on that?
I believe this is an arraignment. If I'm right.
Is it an arraignment? It's a pretrial conference.
Oh, that's right. You're right, Judge. I'm sorry.
Thank you.
There's co-defendant, obviously, with the Dylan being the next person on the docket. I've already submitted a conflict request. Sounds like there was some conversation had with Ms. Atherton that I don't know if that's going.
Schedule this for a negotiation date on May the 15th, next court date on May the 27th. And conflict counsel needs to be provided for either Constant or Dylan. And they need to talk to them before then.
Yeah, I've met with Dylan. I'm keeping his case. It's Constance that we're getting
Okay.
counsel for.
Okay? So your attorney will be to talk to you. You're gonna.
Okay.
You'll do a transportation order to get you on 15th for negotiation at 27th court date. We'll call Dylan up now. Commonwealth versus Dylan Cherry.
He's on his way up, Judge.
Okay. You have Amy Cropper there now?
Yes.
Oh, there's Dylan. Commonwealth versus Dylan Cherry, 26 CR 0013. Are you Dylan Cherry?
Yeah,
Were you born in 1991?
yeah.
Last four digits, social security number 26. What are the last four digits of your social security number?
9680.
19 what?
9680.
9680, okay. Okay, you're here for a pretrial conference. It was just announced, I guess you were in the room, that
Yeah.
it's a conflict as far as counsel between you and Constant. They're gonna appoint you a conflict lawyer to represent you separately. And you'll be transported here for a negotiation conference on May the 15th, and the next court date's May the 27th. Okay?
All right, thank you.
Okay. Amy Cropper. Are you Amy Cropper?
Yes, sir.
Good morning. This is 26 CR 00020. Ms. Cropper, are you 1981 was your year of birth?
No, they're
Yes.
ready to go.
Last four digits, social security number 3772. You're here with the purpose of arraignment. Your attorney is here in the courtroom. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substances and possession of drug paraphernalia. Also with failure to maintain insurance on the motor vehicle and disregarding a stop sign. Counselor, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, and are not guilty, plea reserving all pretrial motions.
Yes, Judge.
I'm signing a reciprocal discovery order, ma'am. Says that your attorney is to receive from the Commonwealth information to help you prepare your defense. I'm scheduling you for a negotiation conference on May the 15th, and the next court date is on May the 27th.
Judge, may I inquire about our bond?
What is the bond in this case?
15,000 surety.
15,000 clerk approved surety is low bond.
Can I get that low?
It is low. I mean, all somebody's got to do is come in and show the clerk that they're have.
Okay, Your Honor, somebody in my family came and tried to do that, and they was telling them that it was a property bond.
No, it's not a property bond.
Okay,
So have them come back and try again, okay?
Okay,
Well, I guess what the clerk may require that they show some proof of
That they own
ownership of
something
property.
that's worth at least $15,000. They have to show some proof. I mean, you can't come in and not be worth enough money to pay the bond to vote. They just need to bring some proof that they own a piece of property or
okay.
cars do it. Vehicles won't do it, but something else.
Judge, I would argue that this is a possession charge that's presumptively probated. $15,000.
I can't hear you.
This is a possession charge that's presumptively probated and also presumptively ROR. And 15,000 surety, not everybody has access to somebody
Well,
with
I'm
$15,000.
gonna let her come in and try it. If she doesn't try it, then you can get the Commonwealth with an agreed order. Okay? Have somebody come back into the office and make an attempt to do a bond for you, okay? And your attorney will be monitoring. If you can't, he'll bring it up with his arguments to the Commonwealth attorney and we'll take a look at it then, okay?
Okay, thank you.
Thank you. Albert Davis.
Davis. Andy.
Are you Albert Davis?
Yes, sir.
Good morning. This
Good
is
morning.
26CR0019. Mr. Davis, were you born in 1971?
Yes, sir.
Last four digits, social security number 8453.
Yes, sir.
We're here for a pretrial conference. What does the Commonwealth have to say?
We have a plea in this case, Your
Is it
Honor.
a felony plea or diversion?
It's felony plea.
Okay. I've just been informed that motion's been tendered that says that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in 26CR00019?
Yes, sir.
Is your judgment impaired today?
No, sir.
You discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept this plea, I need to go over
Yes, sir.
those rights with you and see if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything, right to speak, trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, called to testify against you, right to produce evidence, right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and a right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a plea of guilty, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept any recommendation. Prior to accepting any recommendation, I'll await the pre-sentence investigation report by probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you will have the right to withdraw your plea and proceed to trial. Do you understand that?
Yes, sir.
Mr. Hunley, what is the Commonwealth's recommendation in this case?
Your Honor, upon a plea of guilty to possession of a controlled substance, first degree, namely methamphetamine, the defendant shall receive a sentence of 3 years. This sentence is to run consecutively to Cumberland Circuit Court 24CR00063 for a total of 6 years. The 6-year sentence shall be probated for 5 years. Probation is to be supervised. As a part of his probation, the defendant agrees to enroll and complete the Cumberland County Specialty Court. Defendant shall pay costs at the discretion of the court. Defendant agrees that any evidence of drugs be destroyed in accordance with the laws of the Commonwealth.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you committed acts charged in the indictment as amended?
Yes.
Knowing your constitutional rights, as it explains to your desire to proceed with this plea and allow the court to fix your punishment.
Yes.
You understand that any future convictions of felonies could be enhanced as far as range of penalty because of this plea. You understand that?
Yes, sir.
Okay, now bring the document up here, Counselor. I'm gonna turn to the signature page and shoot, this is your signature. Is that your signature on there, sir?
Yes, sir.
Okay, I'll accept the plea, order pre-sentence investigation report to be done, schedule sentencing for May 27th. I guess we'll need to sign a referral order to,
He's already been referred and conducted in the drug court. So I think he's ready upon their, I'm sure they're ready to do our orientation on him.
well, he's gotta be sentenced first. So as soon as he's sentenced, hopefully on that day, he can be prepared to be
Would
let
the
out.
court consider waiving sentencing? He's had this previous case in 24 CR 63.
Has he been in jail since then? Let me see when the last pre-sentence investigation was done.
Twenty-four CR 63 case. To the precinct investigation you're referring to. That was done on September 20th, 2024.
How long has he been incarcerated since then? Or is he out? If he has been incarcerated since that last pre-sentence investigation report, I will let that pre-sentence investigation report stand.
He's been in since at least February, and if not a little bit
Well,
before.
I know.
January 15th.
What's the gap in time? When was he sentenced in the previous case?
1 second.
Since October 24th, 24, he'll be sentenced.
Did he go in then?
That is probated then.
He's been in jail since January 14th, which is the date of the offense in 26 CR 19.
Well, I'm gonna have to have a pre-sentence investigation for it. There'll be an interview and if it appears that nothing's happened of significance, we might advance that sentencing at another location, okay? That accommodation. Thank you very much.
Judge.
Richard Ferguson.
Ferguson. Got another man ready to go.
Commonwealth versus Richard Ferguson for sentencing. Are you Richard Ferguson?
Yes.
This is 25 CR 006. Mr. Ferguson, were you born in 1968?
Yes.
Last four digits, social security number 0521.
Yes.
Okay. We're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Did your lawyer go over this document with you here?
Yes.
Okay. Counselor, is it substantially correct?
No substantive errors to report, Judge.
Okay. Is there any reason why this gentleman should not be sentenced?
No, Judge.
Okay.
Okay, I found this on the web for reason why this gentleman should not be sentenced.
Phone picked it up.
Okay, I might have some help out there,
No,
Judge.
no, out of nowhere. Scary. No reason shown why this gentleman should not be sentenced. He should be sentenced 3 years. And shall be applied in good time. What the court costs involved?
He's already got it, right?
It's already paid the court costs, so there'll be no additional court costs. Thank you very much.
Judge,
Would you care to call Taylor? I've got a 1 o'clock in Nashville, if possible.
Okay.
It'll take just a second.
You got William Taylor. Can we bring William Taylor on up?
Yes, sir. Come on, Taylor.
Makes sense.
I got 2 meals ready to go.
Commonwealth versus William Taylor, 25 CR 0084. Are you William Taylor?
Yes, sir.
You born in 1995.
Yes, sir.
Last 4 digits, social security number 3136. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report to go over it with a lawyer yet?
No, I haven't went over it with anybody, but I
I
think that's what they gave me last night.
Called the jail, they were short staffed, so they weren't able to let me do it by phone. So I guess if you can pass this for the same date, Miss Atherton is gonna be here the next time.
Okay, well, you have a right to go over this with your attorney before we do the sentencing, so I'll pass it to the 27th of May, and your attorney will be able to meet with you before then, okay?
So we're moving it to the 27th.
Pardon?
Okay. Thank you, sir.
I'll let her know, Judge. Yeah, thank you.
Was he supposed to be probated?
Another meal.
What? I don't like this. I don't like him having to sit up there another month. Was he supposed to be probated
I believe
today?
that's correct, Judge.
This is not right, because this attorney sat on her duff and didn't get up there and then didn't show up for his sentencing. I don't like this. Do you see anything in this report that you know is correct? What does the Commonwealth have to say about it?
I don't know very much about it, Your Honor, but certainly I would agree with your statement. If he's there because the attorney didn't show.
Okay, bring
Mr. Taylor, he's coming back, Judge.
okay. I'm not gonna make you sit there another month because your attorney.
Thank you, sir. I appreciate that.
What I'm gonna do is I'm gonna go ahead and do the sentence here. And then if you, after consulting with your attorney, if you find anything that needs to be corrected in the pre-sentence investigation report, you can come back before the court.
Okay.
Okay.
Thank you, Your Honor.
Oh, wait just a second. On plea of guilty possession of controlled substance, defendant shall receive 3 years, run concurrently for 3 years. Defendant shall be released from and should be probated for 5 years. Probation be supervised. Defendant agrees to forfeit the Walther PDP compact 9mm to Cumberland County Sheriff's Office. What are the court costs about?
$220.
$220. I'm gonna allow you to pay it $50 a month. First payment start 30 days from today. Your probation to be supervised. When can you come to probation pro-op?
If he's gonna be released today, he can come after this evening. If not, it'll be tomorrow morning, Your Honor.
Okay, well, I'm gonna let you get out in the morning and go straight over probation and parole office, okay? 9 o'clock?
That sounds good, Your Honor.
9 o'clock.
Mr. Taylor, call Miss Atherton when you get out, please.
Okay.
You can find her. Okay, thank you.
Where's the y'all you tell me that privilege.
I'll go over.
Thank you.
Yeah. Okay, Jason Hook.
Judge, thank you.
Folks.
Commonwealth versus Jason Hooks, 24 CR 0047. Are you Jason Hooks?
Yes, sir.
Were you born in 1973?
Yes, sir.
Last 4 digits, social security number 7669. Grand jury
Yes, sir.
ready? They are ready to go. After this one, I'll see. This is on a probation revocation.
Judge, we would stipulate, if that pleases the court, to the violations.
Okay. There's been a stipulation on your behalf, Mr. Hooks, that you violated. So I will revoke the probation and allow you to begin your sentence, okay? Thank you very much.
Thank
Yeah.
you.
Yeah, let's, bring the grand jury back.
Got two mails ready to go, two mails ready to go.
Heard my dad and sister.
Somebody out there?
This is, we'll pick up with Mr. Hurst. If you'll turn your camera off just for a second here.
Yes, sir.
We're gonna bring the grand jury back in.
All rise, Cumberland County Grand Jury.
Okay, everyone can be seated. The four person the grand jury. Mr. Foreman, if you, nine or more of y'all agreed on the papers you have there?
Yes, sir.
Presented to the bailiff, and you can have a seat. Okay, everything appears to be in order. I'm going to, I'm going to sign this document here. And either arrest warrants or summons will be sent to the individuals who have been indicted to make sure if they're already incarcerated or whatever. We usually do summons to additional arrest warrant. Set bond sufficient to assure their appearance here and to protect the public if necessary. I want you to take note that the next time you come here will be on May the 27th, not the 28th, but May the 27th. Because we have a significant occurrence on the 28th, May the 28th. My birthday. I know y'all are excited about that. I'm excited to, I hope I get to enjoy it. So, but we will be here on May the 27th, okay? So y'all can be excused if you want to. All rise for the grand jury. Okay, Adair County, let's pick it back up here with James Hurst. James Hurst. Are you James Hurst?
Yes, sir.
Morning. Were you born in 1970?
Yes, sir.
Last four digits, social security number 2119. You're here on shock probation revocation on 22 CR 0013 and 22 CR 0038. What's Commonwealth have to say? Is there a stipulation here?
Judge, this is one that, of course, I'm not listed on the schedule here, and I think he had Mr. Poindexter at one time, and I need, if it's gonna be the public defender's office, I'm gonna need time to get a hold of the motion and meet with Mr. Hurst.
How much time does he have waiting on him here? Mr. Hurst, your public defender here says he's not comfortable going forward until he gets to talk to you about this more. So I'm gonna put it off to the 27th of May 27th, and he'll be up to talk to you. What? Okay.
All right, sir.
Thank you very much.
Thank you.
Jennifer Moore. 25 CR 0080. Are you Jennifer Moore?
Yes, sir.
Good morning. This is, are you born in 1982?
Yes, sir.
The last four digits, social security number 8379.
Yes, sir.
You're here for the purpose of arraignment today. You have the right to remain silent. You represent the Office of Public Advocacy. The grand jury of Cumberland County has charged you with possession of a firearm by a convicted felon. You understand what the charge is?
Yes, sir.
Counselor, you acknowledge the identity of your client received the indictment, wait formal reading and enter plea not guilty, reserving all pretrial motions.
Yes, Judge.
Are there other charges that are pending against Ms. Moore? Is this a subsequent indictment?
Judge, this is from occurrences of April 2022, and my understanding, it came through district court and no probable cause was found at that time. I'm not exactly sure.
Well, she's been indicted.
Right. So I know that's not a conclusion to the case. I'm not exactly
Yeah,
sure what's been
I
picked
just
up.
didn't know whether there were any other charges out there that, where this was a superseding or subsequent indictment. Have you talked to her yet?
No.
Okay, well, you need to talk to her. We'll set May 15th as a negotiation day and May the 27th is a court date. You'll need to do transportation officers.
I would like to inquire about her bond though.
What is her bond? Okay, this indictment was a 25 case. So I don't know, you'll need to talk to the Commonwealth about the Commonwealth know anything about the case?
I just know what the charges are, Your Honor.
What's the bond again?
If she wins.
No, she's been, yeah.
Oh,
Well, it is a firearm case. If you'll talk to the Commonwealth and get their position on it, maybe we'll both know a little bit more about it. Okay, I'll take a look at it. Your attorney has inquired about your bond. He's gonna get a hold of the Commonwealth Attorney's Office and see what the nature of the charge. I don't know anything but the charge. I don't know about anything about the facts, so he'll be up to see you soon, okay? Thank you very much. Yeah. Emmanuel Santiago Vega. Are you Emmanuel Santiago Vega?
Yes, sir.
You born in 1982.
Yes, sir.
Last four digits is social security number 2451.
Yes, sir.
Public advocacy, are you in on this case now? And has Mr. Perrigan listed on the docket?
If we're appointed on it.
Well, I don't know. Who is your attorney, Mr. Vega?
Carissa Miller was.
He has a district court charge and he was appointed the public defender's
I'll
office.
continue that point. We're on a probation revocation. Obviously, you haven't had an opportunity to review that. Is that correct?
Correct. I'll need to get the motion from the
Get
Commonwealth.
the motion and your attorney will be up and meet with you in the next few days. And we will schedule the hearing on the probation revocation for the 27th. It's not fair to you to proceed without having an opportunity to explain your side to your attorney. Okay. Thank you very much. Wesley Smith. Wesley Smith.
Got a minute, resolution. Just wait for a deputy. to come
Wesley,
in.
are you Wesley Smith?
Yes, sir.
This is 24 CR 0072. Mr. Smith, were you born in 1993?
Yes, sir.
Last four digits, social security number 2348.
Yes, sir.
You're here on a shock probation revocation. What does the Commonwealth have to say? Shock probation revocation.
no, I'm ready to proceed.
Okay,
Judge, this is another one that I think the motion was filed several months ago before I was involved. I didn't know about it until the docket. I got the docket yesterday.
your attorney says that he hasn't had an opportunity to consult with you or go over the allegations yet, so it would be in your best interest to continue this revocation here into the 27th, so it's not fair to you to proceed until you talk to him, okay?
Yes, sir.
Thank you very much. Brian Thompson.
Mail, ready to go.
Brian Thompson, 20 CR 0066 and 26 CR 0027. You're represented by the Office of Public Advocacy. You have an indictment here. You have the right to remain silent. The grand jury of Cumberland County returned an indictment charging you with possession of controlled substance in the first degree. Counselor, you acknowledge the receipt of the indictment, waive formal reading and enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Now, there is also a probation revocation, 20 CR 0066, but we'll let them both be negotiated on May the 15th at 9 a.m. You'll need a transportation order. Your attorney will be up to discuss these things with you. Your
Okay.
next date is on May the 27th. Thank you. Carol Walker. Harwell versus Carol Walker, 25 CR 0085. Are you Carol Walker?
Yes, sir.
And this is also 26 CR 0017. Ms. Walker, were you born in 1965?
Yes, sir.
Last four digits, social security number 9875.
Yes, sir.
And we have a pretrial conference. What do we have?
Judge, Ms. Walker obviously has two cases. And you know, the latest one, 26 CR 17, is slightly more serious than the previous, although they're both similar. I'm working on these. I've found some background information on her that I didn't have previously. And I think
You want to
that's-
have another negotiation day?
Please, Judge.
The negotiation day on May the 15th and the next court day on the 27th. Ms. Walker, your attorney says that he's found some information that might be helpful. And that he'll be up and talk to you about it, okay?
Thank you.
Thank you very much. Byron Weber. You're ready. Commonwealth of Kentucky versus Byron Weber, 26 CR 0023. Are you Byron Weber?
Yes, sir.
You born, good morning. Were you born in 1961?
Yes, sir.
Last four digits of your social security number 7523.
Yes, sir.
Okay, you have a right to remain silent. Your attorney is here. The grand jury has charged you with wanton endangerment in the first degree in possession of a firearm by a convicted felon. Do you know what those charges are?
Yes, sir.
Counselor, you acknowledge the identity of your client, receiving indictment, away formal reading, and it's entered plea not guilty, reserving all pretrial motions.
Yes, sir.
Set a negotiation day up on May 15th and the next court day on the 27th. Both of them are convicted. Mr. Weber, your attorney will be up to discuss and prepare opposite the reciprocal discovery order that requires the Commonwealth to give them evidence they had to help you prepare your defense. He'll bring that up and talk to you about your defense in the next few days, okay?
Okay, thank you.
Thank you very much. Austin White.
White, come on.
Austin White.
Weber, just stay there till the deputy comes. Got it in the mail, ready to go.
Commonwealth versus Austin White, 26 CR 0018. Are you Austin White?
Yes, sir.
Were you born in 1999?
Yes, sir.
Last four digits, social security number 26 CR, 8022.
Yes, sir.
We're here on 26 CR 00018 for pretrial conference. What's the Commonwealth have to say?
Looking at the file, I believe that he'll need some time to confer with his attorney.
Okay. 15th, do a negotiation day on May 15th, the next court day on May 27th. Your attorney will come up with information to give to you, help you prepare for your defense, and then together you'll be brought down here so you and he can have plenty of time to talk and do negotiation with the Commonwealth on the 15th, and your next court date then would be 12 days later. Okay?
So I'll be brought there on the 15th.
Yes.
Okay.
Yeah.
All right.
Thank you.
Thank you.
Richard Whitlow. He'll be able to talk to you before then, though.
Okay. All right. Thank you.
Richard Whitlow. Yeah. Commonwealth versus Richard Whitlow. Are you Richard Whitlow?
Yes, sir.
Mr. Whitlow, were you born in 1975?
Yes, sir.
Last four digits, social security number 0884. We're here
Yes, sir.
today in 25 CR 00079. Is there an agreement here?
There is, Judge.
Okay, is it a felony plea or?
It'll be a felony plea.
Mr. Whitlow, I've just been informed that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
It's plea freely and voluntarily given.
Yes, sir.
You're the same person named in 25 CR 0079.
Yes, sir.
Is your judgment impaired in any way today?
No,
You know
sir.
what's going on? Is your judgment impaired? Do you have any impairment? Are you mind clear?
I'm just ready to get this over with.
Okay. Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yeah.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case? You understand
Yes,
that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over them, and then at the end, I'll ask if you understand. If you don't, I'll give you an opportunity to get a side chat situation with your attorney. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, the right to be represented by counsel at the jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, or right to require the Commonwealth to prove beyond a reason without that you guilty charge against you. Understand by entering a guilty plea today that you give up those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll have a pre-sentence investigation report done by probation and parole. After reviewing that, if I decide not to accept the recommendation and impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Yeah, what is the Commonwealth's recommendation, Mr. Hunt?
Your Honor, upon pleading guilty to possession of a controlled substance, namely methamphetamine, the defendant shall receive a sentence of 3 years to serve. This sentence is to run concurrently to Barron Circuit Court 25 CR 00170. Defendant shall pay costs at the discretion of the court and agrees that any and all drug paraphernalia or contraband be disposed in accordance with the laws of the Commonwealth.
Is that what you agreed with, sir?
Yes, sir.
Okay. Are you doing so of your own free will because you committed the acts charged in the indictment as amended down?
Yes, sir.
Knowing your constitutional rights, explain to you still your desire to proceed with the plea, allow the court to fix your punishment. Is that correct?
Yes, sir.
You understand that after any guilty plea, future convictions could be enhanced because of this felony plea as far as the penalty phase. You understand that? Would you bring
Yes,
this
sir.
up here?
Yep.
Is that your signature on there, sir?
Yes, sir.
Okay. I'll accept a plea order, pre-sentence investigation report be done by probation and parole. Schedule the sentencing on May the 27th. Probation and parole officer will be up there. Was he going to be probated and then run with something else?
No, sir. Sir.
It's running concurrently with Barron County where he's got 2 years, so he'll have a 3-year sentence, and he's probably got a sentencing coming up in Barron County real soon. But
So it will run.
I've already,
Okay.
I've already been sentenced in Barron County and everything. I done a PSI report last week for Barron. I've done a PSI report for probation and parole, 2 weeks ago, I think. Something like this. Yeah, like 2 weeks ago. And,
Was it substantially correct?
yeah.
I'm going to go ahead and waive another one then. If you had one.
Yep.
Just waive it. Go ahead and enter the sentence, enter the judgment today.
Thank you.
That'll get you farther along a little bit, okay?
Yep.
Okay, thank you very much. Dare County, you have anybody else we haven't seen?
No, sir, that's it. Thank you very much. Have a great day.
Thank you for professionalism, your cooperation, your excuse.
Thanks, sir. Have a good day.
Anybody else here on a criminal matter? It appears to be no one else here on a criminal matter. We'll reconvene at 1 o'clock. Is that correct?
Look at the completion docket, docket.
Got what?
The virgin completions.
Okay, diversion completion docket.
Let's just do those.
Okay, let me pull that out.
Thank you.
We have a diversion completion docket here. The Commonwealth is aware. Robert Kelly is reporting to have completed diversion. Is that correct? Commonwealth have any objection to report?
No objection,
Hannah Scott, diversion completion.
no objection.
Okay, we'll enter orders accordingly. Thank you very much. We now are recessed until 1 o'clock. Go off through
Yeah, just never know. They said, the property said.
It's the law, you're supposed to be right there.
Right, I said it to be interested, if you go far, sign it.
I can find this.
You saw my other part of the message, didn't you?
Yeah.
Okay.
Maybe not, I'll say to ask this, if you've not had time to review those.
I did review them, I went over with them. I guess the problem is the actual medical records only indicating UTI, hypertension, and anxiety disorder.
Well, why don't you just expert and call nurse, because she knows.
Everything.
Everything.
So I saw the nurse's notes, like trembles, noted on the nurse's notes, so that was the only thing close to a seizure.
They think about that, so go through. So I'm relying on all this, I'm just what I've been told, I'm not. I think it's.
I know she had went to the hospital twice and she's with UTI anxiety disorder, and said outside of Compton.
Yeah, they're very about it. And honestly, well.
Well, we did that one. Gave me a bed. You know, but it's. You know, I was not going to say it. When it's speaking about it's speaking of pedophile. So it's not clear that you understand. So we said about what I mean, very special. She's learning.
Yeah, you bet. It's clock coming up. I'm ready. 7 o'clock. I've got a 6:30 MRI in the morning, so I move early. She's supposed to.
I like bringing up the.
Just that. There you go. There you go.
It's not about me saying you're curious, it's about your boyfriend. So. It's really. Change that.
That's what happens.
Yes.
As far as I'm concerned.
Yeah, I haven't been in there since, but he said he had found. He was going to be put together. I guess I'll be
She sounded exactly. All right, from the circuit court now, State Farm Judge David Williams presiding.
Thank you. Everyone have a seat. Ready for the child support docket?
Judge.
Long versus Long.
Judge, we're asking that matter be reviewed, the July motion date.
Barngrover versus Marion.
Judge Commonwealth is asking for a order of arrest for Mr. Barngrover. The court recalls on the March circuit court date, the court entered an order holding him in contempt. He was allowed to purge himself by paying $1,000. He has not done so, and in fact, has made no payments since September of last year. So I've included an affidavit. And I'm asking the court to enter an order of arrest.
Okay, purge himself by paying
$1,000.
dollars still.
Thank you, Judge.
Got 2 minutes to go, so I'll just. Okay, we'll start a docket called Westbend Mutual Insurance Company versus Fletcher Excavation.
Afternoon, Judge.
Oh,
Judge Mike Van Sickle for Westbend. Afternoon, Judge.
hey,
Judge, this was on for our motion for summary judgment, and it got passed today. There was a couple issues that had come up last time. One was that the bond, there was language in the bond that essentially said that any claim or any lawsuit arising out of a bond claim had to have been filed within 1 year of the last service essentially being rendered by whoever was making the bond claim. And the bond claim was paid by Westbend, and I've looked at it. It looks like the bond was paid by Westbend more than 1 year after the last service was provided, from what I can tell. Judge, I think the other issue was that the defendants had stated that no lien waiver was obtained. So Judge, we passed it today so that we could address those issues. There's the first issue with respect to the limitations period that's in the bond. I asked Westbend for a copy of the bond, like for a full copy of the entire bond with all the terms and everything. Apparently they can't find the original bond. Well, we've got the original bond form, but as far as with all the terms afterwards, they aren't able to locate that in their file. They're still looking for a copy of it somewhere. However, it is a pretty standard, all candor. It's an AIA Form 310 bond, and all of the terms are pretty much identical in all of those. And so I have no doubt that section, and I don't know if the Fletchers have a copy of it either. Somehow she knew that language when she had emailed the court, but well, they may have a copy of it. I don't know. But Judge, I would argue that it doesn't matter, even if Section 12 says that bond limitation, because at the bottom of Section 12, it also says that if any statute, any statutory provision in the state basically makes this provision void, then we go with the statute. Well, there's a statute in Kentucky, which is Section 413-090, Section 2, that places a 15-year limitations period on any action arising out of a bond. And I do have a copy of that statute, Judge, or would like that.
that's okay. Sorry.
You don't need it, Judge. Your Honor, essentially, the indemnity agreement is where we look at, and it gives the sole discretion to Westbend to settle this. And Judge, the owner of whatever construction project, they need a solvent surety to guarantee the job gets done. Contractor needs a bond to get the job. And so the surety has to protect itself. And it does that by making sure that an indemnity agreement is executed. The Fletchers and Fletcher Excavation, they bargain for what is in that indemnity agreement. They're getting the bond, and so they're they're executing that indemnity agreement, they agree to everything.
But I think we've already, thought what we were coming back today for was to give the Fletchers an opportunity to show that the amount of the bond that was paid, the amount of bond that was paid would increase the amount of indemnification. In other words, that they had paid some of these contractors or they had paid the contractor and the insurance company had gone ahead and paid the contractor without giving any offset as to what Fletcher Excavation had previously paid.
And Judge, I think that we had, and I'm sorry if I misunderstood, but and I'm not sure if the Fletchers have any additional proof regarding their.
If I may, Judge, the last time that we were here before the court, you asked essentially what our argument was as it pertains to not, the offset provisions, but because of the underlying claim having been paid by the surety in excess of the time in which the actual supplier could have filed a materialman's lien or asserted their claim against the surety.
That was part of the issue.
That was certainly part of the issue, Judge, and we have tried to locate the actual bond. We have a partial portion.
Well, the bond language is not as important to me as whether or not the time it expired where a materialman's lien could have been filed.
And Judge, if I may, under Kentucky law, and I thought I had printed the statute out, I have not, but I do know the statute is KRS 376.080. It says that a mechanic's lien has to be filed within 6 months after the last day the contractor provided labor or furnished materials. So the time had passed, by the time this claim settled, the time had passed.
Settled?
By the time Westbend paid Consolidated Pipe and Supply Company, the supplier, by the time Westbend had paid their claim, that 6 month period for filing a mechanic's lien had passed. Judge, I'd actually thought that what they wanted was a copy of a lien waiver saying that they are no longer going to be able to, that Consolidated Pipe was basically waiving the right to file a lien. That wasn't necessary anymore by the time this was settled by Westbend. But and I don't think that the fact that a lien couldn't be filed anymore meant that Westbend can't. I don't think that meant that Westbend couldn't settle the claim. I mean, after all, Consolidated Pipe and Supply could still sue, even without a mechanic's lien. They can still sue Fletcher Excavation and Westbend for not settling it. They can still sue Westbend for bad faith, even if that 1 year period has passed. And I don't think that 1 year period is applicable, but they could still sue Westbend for bad faith. And so that's why Westbend says, hey, it's in our sole discretion. As long as we're not acting fraudulently or in bad faith, it's in our sole discretion to be able to settle this.
What about offsets that your clients are entitled to? You originally said that they had paid some of this or they had returned some materials, et cetera. Do you have any proof of that?
Judge, the last time we were here.
Just answer my question.
We have, yes, we do. We have proof that there had been.
I didn't see them filed. I looked at the pleadings. I didn't see them. Did you see them filed?
The concern, Judge, that you were asking for was whether or not there had been anything paid to Consolidated Pipe, which is the underlying provider, after this had been negotiated or settled.
According to the pleadings that were here, Fletcher Excavation agreed that they owed the money and started making payments. Is that correct?
Judge,
am I correct?
I
saw the pleadings today. Am I right? Am I looking at the wrong file here?
Judge, that's what we put in our complaint. And although they didn't necessarily admit that in their depositions, in the emails that from Emily Fletcher to Westbend, she said, all right, I'll pay it. Can I set up a payment plan? And they were like, yeah, Westbend said, would you agree to $1,700 a month initially? And she said, sure. And that would be until the amount was paid in full. And that's what they started paying.
So what I'm interested in, and whether I'm right or whether I'm wrong, and I've read this and read the pleadings and read this, it appears to me that the bond was appropriately paid. But I want to know how many payments the Fletchers had made that should have diminished the amount of payment, or if there were materials returned that should have diminished the obligations that they had to the company.
And Judge, we would happily comply. The last time we were under the impression that we were really trying to address the underlying issue about whether or not Consolidated Pipe still had a claim when Westbend had settled that claim. And we had tried to find the bond language, even Westbend themselves don't have the bond.
Whether Consolidated Pipe had a claim against who? The Fletchers?
That's correct. If they still had the affordance to attach a lien, and then if they had.
Well, okay, he's addressed the issue as far as the lien attachment, even if the lien, the reason you have these construction bonds primarily is for the protection of the owner of the property, not, or the general contractor at least, not to have these liens pile up after it's over. And so if these people aren't paying their creditors, that's it. But that doesn't mean that that's the only purpose for the bond. Is what you're saying. The purpose of the bond is to guarantee payment to any provider, not just for the lien purposes. It goes beyond just lien protection. So and whether it needs to be brought within a year or whatever, I would say that that's probably mirroring the time that you could expect a lien to be filed or enforced. I think that's probably what that language in the contract would be about. Now, I believe that once this bond was put in place, it guaranteed the payment of these suppliers. And I'm going to rule that way, but I want to make sure that the Fletcher, and I might be wrong, but I want to make sure the Fletchers get all the offsets they're entitled to for any payments they made under the agreement to make monthly payments, and or any things that any of the material that they returned to the company. And I've asked for that, and I still don't see that. Now, do you think those exist?
Judge, yes, we do have, I do know they exist. The most recent time we was here, we were trying to address that other issue. Speaking with counsel prior to the case being called, the parties are in active negotiations to try to get this resolved. And I would make a request, Judge, that we be afforded this one last opportunity to come back in May and provide any further documentation or arguments associated with the motion for summary judgment.
Okay, I don't want any arguments on the motion for summary judgment. I'm going to enter at that time. I'll hold off entering that. But what I want is offsets. I want offsets and payments.
And Judge, I will say, as far as the payments that Fletcher has already made to Westbend, I think those are all of the checks that they wrote to Westbend, that's all included and documented and should be attached to the memo for our motion for summary judgment. Because I think the original amount owed, the amount of the bond claim that got paid was like $68,000, and I think the Fletchers made around $10,500. Well, it's in the memo, but Judge, they made over $10,000 of payments, and we've deducted that amount. And so what we're asking for is 58 something or other, and I think that is.
Well, I will give you an opportunity to look at that offset. It's the only thing
yes, Judge.
And then whatever other offsets that the Fletchers said that they were entitled to, they never provided proof of that to Westbend. So if they're able to get that, great. I think that's on them at this point because I think the burden of proof shifts.
You get the offsets, and we'll come back here on May 27th, and it'll be the last day we're here.
Understand.
It'll be final.
And Judge, if counsel could provide that to us a couple weeks before the hearing, so I'd be able to.
Let's say 10 days before the 27th. That anything you're limited to providing any offset that you think you're entitled to and proof thereof. Because there could be other payments to the supplier that don't include this. So we need a full account of everything that was provided and everything that was paid and see what the difference is and compare that to the indemnification claim that you have. Okay?
Judge, we have provided the full account of everything that Consolidated, all of their invoices for all the supplies. So just any of the offsets is really all we need.
Thank you.
Okay, thank y'all very much.
Thank you, Judge.
Yeah. Ray versus Cal.
Afternoon, Judge.
Hello. I couldn't really tell by the motion what we're doing here today.
Judge, I've asked for Ms. Cowan's visitations to be reinstated to supervision and asked for her to do some parenting classes. If you'll remember, we had a lot of testimony the last time before the
Okay,
court.
but now it says for supervised visit to be reinstated, exercised by the respondent, due to the child receiving more cigarette burns. Now, I read the filings and there was an allegation in that there were 2 cigarette burns, but Ms. Cowan said that they were insect bites or scratches or something like that. But the child evidently told someone that they were done while she was smoking.
Yes.
Okay, now, what's the deal? Are you still not represented by counsel?
I don't know. I really don't.
Do what?
I don't know where he's at. Yeah.
Who is your attorney?
Hey, Carter. Yep.
I believe Mr. Carter filed a motion to withdraw. I think I received that by e-filing last week.
I haven't heard nothing, Judge.
Well, I didn't sign an order relieving him, did
I
I?
understand. He communicated with me that he was at his National Guard training, and I thought he had communicated with her. So, I mean, I can't speak to what kind of communications his office has had with her, but I do know then I received them.
Was he private counsel or was he guardian ad litem or?
He was
friend of the
private
court?
counsel.
Private counsel. You have a copy of anything that says he's in the National Guard here?
I mean, I have a text message from him, Judge.
What does it say? Is there a motion to withdraw that's been filed?
He texted me yesterday and said I filed a motion to withdraw in this case that you just said tomorrow. I forgot to put in this, it's the order. I've been working in Frankfurt for the Guard all month and didn't receive this motion until I was already here. Yeah, and that's
Similar to what he said. So he said he forgot to submit the order to allow him to be excused, right?
yeah, and it's the motion.
When was that motion?
I filed it on the 16th.
No, when Mr.
Oh,
Carter.
Mr. Carter's motion? Yeah, it was filed on the 17th, last Friday.
Send it directly to the clerk's office or did they send it to us?
He filed it.
He filed. Well, I'm not gonna make her go forward without an attorney, but I don't want you to say anything, okay? Is your desire to smoke? This is wait, I don't want you to say anything. I'm just a rhetorical question. I don't want you to admit anything or anything. But if I were you, or if I was an interested party, I think I would set aside my desire to smoke enough when there have been these allegations about cigarette burns. And do you have a doctor's statement on it?
I do, Judge.
I didn't see the statement. I saw that it was alluded to.
I can e-file these. I just got.
You be back here on the 27th with an attorney. Okay.
Thank you.
Now, what kind of limitation between now and then? Supervised?
I was asking for supervision.
Who was supervising previous?
I live in Columbia right now, so either my sister Amy Cowan can.
Can or can't?
She can.
Judge, I think her parents were supervising
Well,
last
where do your
time.
parents live?
Virtual.
Well,
Yeah.
what about the sister?
She's back there. She's actually with me today.
She's what?
She's with me today. Yep.
My client doesn't know the sister and isn't familiar with her.
Bring the sister around here. Bring your sister around. Yeah. Hello.
Hello, sir. How are you?
Yeah, well, I'm blessed. How are you doing?
I'm blessed to be here.
What do you do for a living?
I stay at home. I'm a home care. My husband works.
You work, so you're a full-time housewife,
Yeah, I'm a
mother. How many children of your own, how many children do you
Oh,
have?
I've got 4 children. They're all grown.
Yeah.
So,
Got any grandchildren there that stay at your house or anybody or?
no,
You haven't ever had any problems or allegations made against you about harming any children or been
No,
social
sir.
service reports? Or anything?
no, sir.
Okay, how far do you live from your sister?
Actually, right next door.
Okay, well, I'm gonna allow her to supervise.
Judge, I would ask if she smokes.
Yes, I do smoke, but we smoke outside my,
I don't want the children inside anywhere that's smoking. You understand that?
yes, sir.
How old is it? How old?
7.
7. Well, 7-year-old will rat you out, you know that?
Oh, yeah. Yeah, no.
So I will tell you that I want a status quo. Don't talk to the child about this. Don't threaten the child. Don't ask him why he said anything. We'll be back here on the 27th. Okay.
Sir.
Thank you very much.
Thank you.
First and Farmers National Bank versus Justin Turner. It's a motion for default judgment.
It is, Your Honor.
Is Justin Turner and or Sarah McKenzie Gardner, are they here today as parties?
Judge, to clarify, Mr. Turner filed Chapter 7 bankruptcy. He's not listed or in the judgment. The judgment that we seek is only against Miss Gardner.
Okay. That'll be fine. Just submit it. Get signed.
Should be in the file, Your Honor.
Is electronically filed. Okay, we'll enter it.
Thank you.
Okay, no problem. Michael Jeffrey Hirsch. Ms. Capps, is this yours?
Yes, Judge.
Okay,
Judge, this is on for a custody hearing. I know we've been here several times on this case. Mr. Herschel appeared, I think, one time, and then he's not appeared any other times, even though I've provided him adequate notice. None of the items that I've sent him have ever been returned. We filed this motion to have the custody hearing back on March the 11th, so he had plenty of time that he could have filed a response or contacted the clerk's office.
where does he live, you know?
The last time we knew, the motion here. He was in Hardyville.
Yeah, what relief do you seek?
Miss Jessica Herschel and Michael Herschel had joint custody. And so we're asking, because of her health condition, and she's here today in support of our motion, that my client, the maternal grandmother, be given custody of the child because of the increasing deterioration in Jessica's condition. And she just wants to make sure the child's provided for and has stability.
You haven't pled that they're de facto custodians, have you?
No, I have
Do you
not.
think they would qualify for that?
I think there is a potential they would, but there have been times because of her health that she's resided with them, so.
I don't think that
But
necessarily.
I do think that they have been the primary caregivers.
Well,
Testified.
I'm gonna give you an opportunity. I feel more comfortable making findings about de facto custodianship and approaching it that way to give them status independent of anything that she might have in case something were to happen to her. You understand what I'm saying?
Yes,
But I will, has he made any attempt to retrieve the child or get around or anything?
he is not, and I know you previously ordered back in last December that he would have temporary supervised visits. Did he exercise one visit? No, he did twice. He showed up 2 times, and then after that, they didn't hear
Well,
anything else.
and
from
where were
him.
those supervised visits supposed to take place?
Well, they were originally supposed to be where he could come and pick the child up so long as he didn't go farther than Glasgow. But then you've also entered an order after that suspending those visits.
Okay, well, if the visits are suspended, that'll be the status quo. We'll leave that there and then give you an opportunity to make some pleadings and argument to award them de facto custodial situation, okay? Okay, thank you very much. The next case is Beatty versus Webb. Okay, you want,
This was our motion for default. I represent Ms. Beatty.
is there any property involved?
No judge and no children.
Yeah. Okay, well, I think that your motion is well taken and we'll go ahead and do a de facto, okay?
Thank
Can
you.
you submit it electronically?
Yes.
Okay, we'll enter it.
Thank you, Judge. That's all I have. Be excused.
That'd be good. Okay. NRA Cumberland County Hospital Association breach litigation.
Good afternoon, Your Honor. Laura Van Note for the plaintiffs.
Hello, welcome.
Good afternoon, again, Judge Colton Hurd on behalf of the Cumberland County Hospital. Here with me is lead counsel Chris Brooker, Mitzi Warwick, and Matthew Palmer Ball.
I have a little issue that's come up about this. My staff lawyer, I think kind of monitors the mail that I get, says that my data might have been breached. And if that's so, I don't probably think I ought to be sitting on this case. I don't go up there very often, but I did go up to take some, during COVID period for some treatment up there. Do you think that we ought to take a look? Is the fact that I've been treated at the Cumberland County Hospital, would that be enough for me to have a conflict situation? Or should I, if my data has not been breached?
Your Honor, I don't believe there is a conflict because you have been specifically excluded from the class by the plaintiff's complaint.
That wasn't nice. But my claim would still survive if they successfully got with it. You know, I'd have a separate claim if there is any claim at all. What about that?
Potentially. We have no problem with you continuing to serve, Your Honor.
That's awfully generous of you. Appreciate it.
Well, Your
Okay.
Honor, I think, yes, we have, in general, do plead that anyone who is acting as a judicial officer over a class action complaint would not be a class member. At this point, there is no class certified. So whether you would be a class member or not a class member is really not where we're at right now. Certainly, you would have similar claims to those brought here.
Well, I just kind of thought that I might be able to get some of my brother and sister lawyers from Jefferson County who have business courts to take this over, you know, but I guess that's going to be possible. Do you want me to, there's a motion to dismiss all claims. There's several motions here. I guess does the defendant hospital have any objection for me to continue to sit on this?
No objection, Your Honor.
Yeah, okay. Plaintiffs don't either, unfortunately. So we'll go down through some of these. Which motion would you like to be heard on the motion? I guess you got 3 different rounds on the motion to dismiss.
That's right, Your Honor.
Let's do them ground by ground. First one is sovereign immunity, correct?
That's correct, Your Honor. And that's the primary argument. As you know, there was a ransomware attack on the hospital back in early 2025. The hospital reported it to HHS and sent notices to all potentially affected people. Sounds like potentially maybe including yourself. The good news is Cumberland County Hospital jumped on it, shut down the attack, and has worked with experts to make sure that it won't happen again. The good news is no medical records were ever involved. There was demographic information such as names, date of birth, social security numbers.
Let's deal with the sovereign immunity aspect of it.
Yes, Your Honor. So sovereign immunity covers counties, as you are probably likely aware.
Painfully aware of
Yes.
sovereign immunity. And
And
in case I
including-
don't understand it every time, but go ahead.
Including county hospitals. They have sovereign immunity. It's been well recognized in
The
numerous
argument was
cases.
that keeping these records would be excluded from the sovereign immunity claim because they weren't in providing healthcare. Isn't that right?
And that is the argument that our plaintiffs have made, and we disagree with that because the argument they're making is based upon a specific federal statutory exclusive immunity that covers community health centers that receive a certain kind of federal funding, where there is essentially a split where it is medical malpractice liability. That exclusive federal statutory immunity applies, whereas some courts have found that essentially administrative tasks of a hospital are not covered. But that's not the immunity that we are moving under today, Your Honor. We're moving under Kentucky's sovereign and governmental immunity, which apply to the entire operation, whether it be a highway garage or an airport or a hospital. County hospitals have over and over by Kentucky appellate courts been held to have immunity, such as in the Fryman versus Fleming County Hospital case. Okay. And the point is, Your Honor, there is immunity from stem to stern, from corner to corner at the hospital, unless there is an explicit statutory waiver by the General Assembly. And there is one statutory waiver by the General Assembly that specifically covers county hospitals, and that is 67-186. And the gist of that specific waiver is that to the extent county hospitals have purchased an insurance policy, whether it's medical malpractice, cyber, covering the negligence of a county hospital, the immunity is waived up to the insurance limitation. Here, the situation is the Cumberland County Hospital did not have any coverage. And so there has been no waiver of immunity, and so the claims must be dismissed.
What do plaintiffs have? We're going to argue these ones. What do plaintiffs have to say about that?
Well, Your Honor, I think the preliminary issue here is the type of information that's available to the respective parties. As the court saw, which is, I think, very unusual, there was almost 100 pages worth of exhibits attached to defendant's motion to dismiss. As we know, we should be talking about the pleadings, the four corners of what's in the complaint. Instead, defendant has put forward extensive information, which it believes is relevant and should be considered by the court. And, you know, regardless of whether all of that should be considered, and I would contend much of it should not be considered, the question of what their insurance is, what it covers, what it says.
What you're saying is this should be decided on a motion for summary judgment rather than to dismiss the pleadings. Is that what you're saying?
Correct, Your Honor. If we're talking about a factual inquiry, especially in a situation where we don't have the benefit of discovery, they have information about their insurance and what it covers and what it doesn't. I do not have that information. I have no ability to have that information.
Immunity is a threshold defense in Kentucky. In fact, it can be immediately appealed depending on what the ruling is. And I'm not saying that, saying
I think that'd be a good idea. Pass this cup from me, you know.
But what I'm saying is that the threshold defense that protects the hospital and immune organizations from any litigation whatsoever. So it has to be decided.
What do you say about that, counsel?
Well, Your Honor, I don't think that the court needs to, you know, ask them to waive this defense. And I think that it could be brought, whether the mechanism is a motion to dismiss. But what I am saying is that without any discovery, I'm handicapped in my ability to respond to this. I don't have the information that they have. And I think that, you know, if the court wants to consider information outside of the pleadings, we need to have, in fairness, the ability to conduct limited discovery. I'm not saying let's try the whole case here, but I need some information.
I agree that you need foundational information provided. So I will hold in abeyance this motion as far as sovereign immunity until limited discovery can be made that would give factual information to the plaintiffs in the case concerning the facts that you assert support your immunity situation. But the discovery stops there right now, okay?
Understood, Your Honor.
What's the second issue?
The second issue is standing, Your Honor. Yeah. And with standing is, you are well aware that standing requires three things. There must be an injury in fact, there must be causation, and there must be redressability. Here in the pleading, it's a very long pleading, the consolidated complaint. There is not an injury in fact under Kentucky law that can be redressed.
Well, they say it's per se, that's what they say, that what the plaintiffs, what are the injuries that you allege for the plaintiffs?
There are numerous injuries alleged, and the complaint is very comprehensive. I will say that we do not have the benefit of an on-point Kentucky State Court case on this question. There have been many data breach cases dealing with the types of damages that would give rise to standing in various other jurisdictions. So we have provided that to the court.
I read in the pleadings one place where you said that release of this information, say, could have create future damages that could be acted upon. Didn't you say that somewhere in your pleadings?
Yes, Your Honor, that is part of it.
Yeah, well, what other part?
So we lay out various types of damages and I will refer to those for the court. So the risk, substantial and present risk of fraud, identity theft, and injury in fact. In this situation, by way of background, there are lots of different types of data breaches. Some of them are very limited, where you're talking about maybe somebody's name, maybe some unique account number with some, business. And then you have the very opposite end of the spectrum, which is what we have here, which is basically a whole package of somebody's personal information. Full name, address, date of birth, social security number.
Mutual damage that could be done by virtue of someone having that information is what you're talking about.
Yes, Your Honor. Very substantial risk of damage with this type of information in particular. You could very easily be one of these people.
So you say it's action, is there a Kentucky case law that says it's actionable to try to recover something that might potentially be dangerous, or does it have to be some kind of loss proved or some damage proved?
Well, I think the potential for future harm, as long as it's imminent, is actionable alone, but that's not all we have pled. We've also pled other damages that have already accrued. So, for example, mitigation efforts. So all of the individuals who were impacted by the breach received the same notice that said, your information has been compromised. You should go out and get credit monitoring. You should spend time making sure that other people aren't using your medical information to impersonate you. So that has already accrued. That time spent mitigating, buying credit monitoring, spending time checking your credit report, checking for new accounts. In addition to that, the diminished value of the personal information has already happened. Emotional distress is another injury, in fact. The loss of privacy of your personal information, especially when you're talking about medical information. The moment that becomes public, think about the types of private things that a person may discuss with their doctor. That's already been disclosed. And the loss of privacy happened the minute that information was compromised. And all of these things already constitute an injury in fact. And I will tell you, Your Honor, various courts have looked at this because this is, it's a difficult question, right? This is not a run-of-the-mill, I got hit by a car, I broke my arm situation. It's a situation where information is taken intentionally by wrongdoers for the express purpose of selling that information so that it can be misused. But first you have to know that it's being misused.
I believe that you have to prove that if Cumberland County Hospital is not relieved by sovereign immunity, that they have to prove that they took every precautionary step that was available to them to prevent this breach.
It's not an all or nothing standard. It's not you did everything. It's you did what was reasonable under the circumstances. And that's subject to expert inquiry.
Reasonably, what other companies did, that would be a defense, right?
Yes, it would be company standard, industry standards in hospitals having, safeguards for information, controlled access.
You would need discovery to see what actions they took to protect the information, correct?
That's correct, Your Honor.
Now, what's the third issue?
The third issue is failure to state a claim, and it has a lot of overlap with the standing issue, which is that there has essentially been no causation, no damages. What I heard Ms. Van Note say numerous times were the words risk and potential, but it has not happened. There has not been in the pleading itself. There is not an allegation of an actual harm to any potential class member that would be actionable under Kentucky law. And we've cited the numerous cases from other jurisdictions, and the plaintiffs have not challenged the legitimacy or accuracy of our citations and the conclusions we draw from them, which is stuff such as fear that something might end up on the dark web, or risk of future harm, or credit monitoring do not give rise to a cognizable claim because there has not been an injury or any causal connection with the Cumberland County Hospital's specific breach. So based upon the pleading as it is, Your Honor, that this case cannot proceed because there's no standing. We don't have that harm. The fact that the breach did occur, we certainly wish it had not occurred. I can tell you that, but there is nothing in the complaint that under Kentucky law this is harm to this person. Their data has been exposed. This particular issue has caused financial harm or harm to another person. It is, so there's no.
So you say in a class situation, they still have that burden to show that there has been damage to individuals or a group of individuals who seek to become a class.
That is correct. And that is sort of a certification issue on and of itself. But as far as the initial pleading itself, the facts that they have pleaded do not rise over that.
Well, here's what I'm going to do today. This is all very interesting, except for the rule against perpetuities and other things we hadn't brought up, but it's pretty interesting sort of legal stuff. I'm just going to rule today that Cumberland County Hospital does have immunity if that's appealable. Okay. There's no reason we go any farther than that until we get that issue. So I will, if you'll submit me a final and appealable order on the immunity issue.
Yes, Your Honor.
Is that correct?
Yes, that's correct.
And counsel, that leaves your other arguments open for another day. But before, let me say, before I enter that order, I want you to provide discovery to the plaintiffs on what you base your immunity claim on. Okay.
Your Honor, we have provided exhibits A to O with our motion to dismiss, which are all of the contracts, all of the history of the hospital.
Okay, is that information sufficient for you?
No, Your Honor, that information is one-sided. That's the information they believe benefits their part of the argument. That's not what discovery is. Discovery should allow me to seek information I think is relevant and may support my arguments.
Your Honor, I don't know what other
Who do you want to discover? Usually
Right.
you discover the other side. You know, you got expert witnesses you want to take discovery from. That's not really discovery. That's taking.
I'm not talking about expert discovery. I'm talking about information regarding, for example, they provided a declaration from the CEO. And I think it's about a page and a half of substance talking about, you know, what type of insurance might be applicable and whether or not.
What was the CEO?
For example, yes.
Well, I want more than just an example. I want you to tell me whose depositions you might want to take to attack foundationally the argument that they have sovereign immunity.
Yes, Your Honor. I think a limited deposition of the CEO, since he has been put forward as a material witness by way of their pleading, and limited document discovery related to that.
Well, look, I'm going to limit the limited. I want you to give me some parameters, what limited is. You know, I had a stepson one time that told me that my warm was his hot, you know, so.
Understood, Your Honor. I think that maybe what would work best here is for the parties to discuss the discovery. So I could, for example, have a conversation with defense counsel about what I think is needed. And we could submit a proposal of a scope for limited discovery that we can agree upon. And that way we can deal with some of these more intricate issues without taking up the court's valuable time. And I believe we probably could do that.
You have a response?
I do have a response. The question is, and this is what our exhibits show as a matter of law, is whether the Cumberland County Hospital was established by the Cumberland County Fiscal Court. And the evidence we have provided shows as a matter of law that that happened. And the plaintiffs in their response brief to our motion to dismiss in no way, shape, or form challenge that the hospital was established by the fiscal court. There's really no discovery that can change that fact.
Let me tell you how I feel about that. And that's plain fact. You make a great argument. But as this case goes up on appeal, I want the appellate court to have more than just the statement that you've had. I want an opportunity to have proof in the record that establishes. I think it will have more weight when it goes up if there's proof in the record and an opportunity for them to ask some questions along those lines. And although it might be an extra pair of suspenders in this case, I'm going to allow that to happen. But I will, before you have to participate in anything, I want an attempt to agree what this limited discovery is to establish the grounds for your sovereign immunity. Okay?
Understood, Your Honor.
We'll stop it there. And if I rule it there, we'll let it go up and let the people in the Court of Appeals or Supreme Court rule on that. And once they rule that, I'll just determine whether I have to do anything else or not. Okay?
Okay.
Thank y'all very much.
Thank you, Your Honor.
Yeah,
Thank you, Your Honor.
yeah. Right, am I now on this thing? This next page. Do what? I don't see that. Timothy Davis versus Jessica Pitcock.